return to the debate on end-of-life care. The next person to speak is Deputy Howell.
Thank you, sir. And I would just like to say to everybody that I'm fully supportive of this end-of-life strategy that we've come up with, or plan that we've come up with. And I respect what Deputy Balash has said, but I do think we should keep them separate, because if for any reason the assisted dying bill did not go through, which I'm sure it will, but just if it doesn't, then we still have this. And I believe it's really important that we look after people in their last year of life as well as we possibly can. I think the GPs used to have something called a gold standards framework. I think they still have it. And when they recognise someone is getting towards the end of their life, they put on that. And then everybody works together to give any individual the best possible end of life and care for as long as they live. Thank you, sir. So please support this proposition.
Thank you, Deputy. Deputy Ferry.
So I rise at this point just to ask that we can raise the defo on Deputy Alex Curtis.
I was content to raise a defo. The defo is raised. So does anyone else wish to speak on this proposition? Deputy Rob Ward.
Thank you, sir. I want to support this proposition. I think it's a... I initially, when I looked at this, I did actually think to myself, why are we not just including this in one law? Why are we not just getting on with this? We voted before, we had a long debate before, a very constructive and very positive debate, actually perhaps one of the most thoughtful debates we've had in this assembly for a long, long time, and we came to conclusions. But then I was, until not long ago, thinking, why do we need a separate law? But I think the points made by the Minister and the points made by the scrutiny panel, points made by other members as well, make it very clear that actually separating this is not an issue. It just gives clarity, and it gives that emphasis on the importance of end-of-life care. We never know what's around the corner, sir, and I think we all have to, this is where the personal and the political come together for every single person, that ensuring an obligatory right to end-of-life care for us all, I think is something I am more than happy to stand up and vote on. I understand the idea of, well, all healthcare should be obligatory in some way. However, there is something distinctly different about how we prepare for the end of our lives. Something I hope we never, well, we will at some point, but I don't want to go down that road, sir, at the moment. I think, sir, this gives a framework for support that we need, and it's reassuring that this can happen and that it can be supported. I support the finances going towards this so that it's actually a realistic proposition in terms of delivering that care, which is really important. And so I hope that we can, I think we can separate this from the assisted dying debate. The assisted dying debate, as I mentioned before, so we've been through for some time ago in great detail. This is one of the assurances that came from that. It shows that we and the Minister and the Department are acting on the advice of the Assembly, on the advice of the Scrutiny Panel, to enable something that this Assembly voted for to happen in the best possible way. And for those reasons, sir, I would urge members to support this proposition today. Thank you.
Thank you, Deputy. Does anyone else wish to speak on the Deputy Gorst?
Thank you, sir. Sometimes this Assembly delivers bitter-sweet moments, and I suspect on my part, it will do that over the course of today and tomorrow. I absolutely support the Minister in ensuring that there is an end-of-life and palliative service that allows all islanders to die well. It's a point which I think has been at the heart of the overall assisted dying debate. And I recall mentioning in a previous speech, and I bring to remembrance a parishioner who came to see us at our constituency surgery, who described to me what can only be a most unacceptable death that his wife had to go through in the hospital. The pain that she suffered, the indignity of being in a 7-bedded ward with a curtain around her. Not only did she suffer that indignity, but she was surrounded by others in that bay who were also coming to the end of their life. And I said in that debate, and I said to him, I have no good answers to that, because no islander should have to suffer in the way that his wife had to suffer. For my part, this proposition, and in due course the legislation, I'll come back to that, does provide a good answer to that constituent. Because I might be of the school that believes that actually this is the most important law that we will debate over the course of this state's sitting, because it will allow all to have appropriate end-of-life care. It will allow all to have appropriate palliative care. Now, I was, as ever, interested in Deputy Balash's speech, because I think he made a very good point, that he absolutely can support Part A, but believes Part B could be delivered in a different way. And I understand entirely the point he was making. I may have been persuaded, but it's not because of the things that Deputy Tadier suggested about money and legislation and resource. Of course, we should put the appropriate resource and legislation in place to ensure that islanders can face death. And that's a broader societal point as well, which I think Deputy Rob Ward just touched on. We should all think about the ends of our lives, and that's something that we find difficult in our modern society, to think about that, to consider those that we love, the effect it will have upon them, and how we order our affairs to ensure that there is as little difficulty for those that we leave behind as possible at what can be a very traumatic time in not only obviously the person dying, but the family remaining behind to pick up the pieces. And the reason I think Deputy Balash made a good point was because he talked about an amendment to the assisted dying legislation, which would mean that the minister would have to issue a statement to ensure that he was, or whoever the minister is at the point then, let's hope it's still the same minister, that he would issue a statement saying that he believed that there was appropriate end-of-life and palliative care available to all islanders. And the reason that has got some merit is because it will be really quite straightforward, relatively, to deliver a piece of legislation that will come through this assembly. It will go through its first, second and third reading. Members in the assembly will agree the legislation and think the job is done. But we all know that in most instances, delivery of legislation is the easy part. It's the provision of the service and the ensuring that there is appropriate care for all those reaching the end of their life, which is the tricky bit. Because that's the bit that is the hard yards. That's the making sure we've got enough doctors and nurses, that we've got the right pain relief models and framework in place, that we've got the right number of beds at the hospice, that we've got the right facilities at the new hospital, that we've got the right workers who will go out into the community and be skilled enough to be able to deliver that end-of-life care appropriately and mitigate the pain of the end of life. That's the hard bit. That's the bit which, if we look at our current health service, we've got thousands of great people doing their very best day in and day out. Many of them overworked. And yet the experience of islanders is not one that we can universally applaud. In fact, many are waiting too long and suffering, not through want of the staff, but just because of, over time, the way that the health service has been built up and managed issues has fallen short of the standard that we would expect, which of course is why the Minister is doing all the work he's doing about reorganisation and governance and thinking about the structure of the health service into the future and thinking about whether it's appropriately funded or not into the future as well. So the hard bit will be providing the service. And I suppose a little bit of me finds Deputy Balash's approach appealing, that a statement needs to be made and before the law is brought into place that there is provision in place. And perhaps he won't like my overall conclusion, but should he in due course bring that amendment despite the passage of this legislation, I think I would find it hard not to support it. I think today I'm going to support both parts A and B, but when the legislation comes forward, I do think there would be great value in the Minister making a statement and being required to do so in that legislation as well, to confirm publicly and therefore create accountability that that service is in place. So this proposition is the sweet bit of where we are in my mind in what we've got before us today, that we will have in place a service that provides the end of life and palliative care to all islanders, because it will be an obligation upon government to provide that. And I think, sir, that I hope that members support it, and I think it's a moment that we can be proud of. Thank you, sir.
Thank you, Deputy. The Dean.
Thank you very much, sir. I would like to endorse everything that I've just heard. This legislation does put a great weight upon the shoulder of the Minister for Health to give effect to that decision. And I know that's an undertaking that was given to stakeholders when we were discussing this time and time again and going to various briefings. So I really do welcome that, because it's absolutely crucial that palliative care is in place before we move on to the next part. And I just want to just change the tone slightly. We've talked about palliative care enabling everybody to die well. Palliative care is also about enabling people to live well until they die. I think that's really important as we approach the debate that is to follow, that this isn't just about dying, this is about living. Thank you, sir.
Thank you. Does anyone else wish to speak on this proposition? Deputy Wilson.
So it's a question for the Attorney General, if I might. And I just wanted to ask if he could clarify whether or not the Health Minister already has statutory responsibilities for providing end-of-life care and end-of-life services.
Thank you. Solicitor General.
I think the short answer to that is that the Health Minister has a statutory obligation to provide health services. This is a slightly different proposal, because it's seeking to legislate to create a specific form of service and to create for the Minister a specific statutory duty. So there is the broad statutory duty to provide health services for the island, within which there might be a debate about providing more precise health mechanisms pursuant to statute, which is what I take this project to be about.
Thank you. Deputy Miller.
Thank you, sir. I'm not going to say a great deal. The Dean has touched on some of what I wanted to say. Sir, this law, as I read it, is creating a statutory duty on the Minister to provide end-of-life care. And at this stage, it is within the criteria for assisted death, which is those people who have a terminal illness, which is expected to end their lives within 12 months. And in this context, it's an essential safeguard against someone opting for assisted dying because of a lack of care or a perceived lack of care. And it is important that people, anyone with a diagnosis like that, is given the care they need. But I do want to pick up on the Dean's point, because we have to remember that there will be many people who are told that they have a diagnosis of an incurable illness which will end their life, but the end of life may be some 3, possibly even 4 years away. We can all think of people who are in that position. And it is important that they have palliative care, because palliative care is about enabling people to live their lives. It's about enabling them to not be in hospital, not be in hospice, to be at home, to go about, to achieve the goals they still have for whatever life they have. Because people who have a diagnosis of incurable illness and a possible time period, they still have goals, and it might be, I want to have one last Christmas, I want to see my new grandchild, I would like to be at my son's wedding. People have goals still, even at that stage of their life, even knowing that they have that end of life coming. And it's important that palliative care is provided to them to allow them to go on, and they know that they can live at home, but if they have a crisis of pain or something, that someone will be there to help them deal with that crisis and to live their lives as best they can. I do share some of Sir Philip's concerns, and I particularly am concerned about some of the comments I think made by Deputy Jeune, I think, that would create wider statutory duties regarding healthcare. I can support this because of the limited criteria, but any statutory duty in terms of provision of healthcare is a hostage to fortune. And we can all think of many, many pieces of legislation, both here and globally, which have been introduced with very good rationale. My particular ones are human rights, data protection, and the discrimination law, which were all brought in for very, very good reason to deal with real issues. And over the passage of time, they are bent, extended, interpreted, stretched to cover things that they were never intended to cover. And I think that is exactly what would happen with any statutory duty to provide health. What does it mean? That it means you're entitled to what you want, when you want it, where you want it, or is it health at the permission of the GP? So I would find it very difficult to vote against any wider statutory duty than is set here. I just want to lay that marker down now. Thank you, sir.
Thank you, Deputy. Does anyone else wish to speak on this proposition? Accordingly, I call upon the Minister to reply. Minister.
Thank you, sir. I think I can sum up relatively briefly, but if I'm a little hesitant, it's probably because I can't read my own appalling handwriting, sir. I'll try and take them roughly in order. I know that Deputy Dublet made a number of points, and they're points that were touched on by several members thereafter in relation to legislating for other forms of care. This is something we can look at, but as I say, I think this is a complicated one, and as I say, a number of people have alluded to those complications already, sir. Assurances regarding access in all care settings, I have no problem with that, and we'll certainly do what we can to make sure that's dealt with properly. The appeals and dispute resolution process here hasn't yet been defined, sir, but it's certainly something that will be over the course of time. Yeah, the ongoing intention to keep end-of-life care aligned with developments in assisted dying. Obviously, I can't go beyond my own remit within this parliamentary term, but hopefully that will be written into this when it comes back to the Assembly, sir. With regard to Deputy Bullish's comments, I don't think I've got a great deal to add. Keeping the two things separate, end-of-life care and assisted dying. A number of members have alluded to the fact that it's not palatable for some people to rely on a law that provides them with end-of-life care being tied up with an assisted dying law, and I think that has to be taken into consideration. And in this instance, if the requirement to provide end-of-life care is linked with the assisted dying law, and the assisted dying law doesn't go through, then the intention to legislate for end-of-life care falls away, which I think would be a shame, sir. In relation to Constable Jackson's point about extra costs for care homes, I think this is going to be relatively cost neutral, because in large part bringing all of this into law really doesn't do a great deal more than oblige us to carry on with the work that's currently being done with the money that was put for this purpose several years ago, sir. I thank other members who've made a number of different points, basically in support. And I think I'll end just by thanking Scrutiny that this has been done in a very professional way. It's been very comprehensive, and so I thank the Scrutiny panel and their team. And I'd just like to say a brief word of thanks for the two ladies. I don't need to name them, because I think everybody here knows who they are, who work in government. We get a lot of criticism of civil servants. That these two people really do work very, very hard and very professionally in producing much of what comes into the Assembly on this subject. So with that, I'd like to thank them and call for the answer.
Minister, it was suggested you might take A and B separately. It's a matter for you. It's your proposition. Do you want to take A and B together or separately?
I think we'll take them separately. I'm quite happy for people to express their opinion as they see fit. So,
thank you very much. The appell has been called for. Members are invited to return to their seats. Dealing first with part A of the proposition. I ask the greffier to open the voting. All members have the chance to cast their votes. I ask the greffier to close the voting. I can announce that part A has been adopted. 44 votes pour, 2 votes contre. Yes.
Those members voting contre, Deputies War and Wilson.
Now move on to part B of the proposition. I ask the greffier to open the voting. All members the opportunity of casting their votes. I ask the greffier to close the voting. I can announce part B has been adopted. 43 votes pour, 3 votes contre.
3, please, sir.
Yes.
Those members voting contre, Deputies Balash, War and Miller.
I'll move on to the draft assisted dying law lodged by the Council of Ministers. The main respondent is chair of the Assisted Dying Review Panel. Deputy Balash, if you are going to ask the Assembly not to debate this matter now, then this is your opportunity before I ask the greffier to read the citation and the Minister to propose the principles.
Yes, sir, I would like to propose that the debate be postponed until the 24th of February. And in making that proposition, may I say that the assisted dying debate is not only going to be the most important debate that we have had during this parliamentary term, ethically and in other respects, but also one involving some complicated issues. The report of the scrutiny panel's experts, I think, makes that clear. For my part, I don't think that it is appropriate for the principles to be nodded through, as the Minister appeared to imply in his most recent email. We need to do justice to the debate. And in order to do that, the Assembly ought to await the comments of the scrutiny panel, which will be available to the Assembly in good time for the 24th of February. The Assembly ought to be able, in my submission, to view the amendments that the panel is going to bring, some in consequence of the experts' report, but others not. We ought to be able to concentrate on the debate as a whole and not have it divided up into two parts. The Minister seems to fear that, I don't want to overstate it, but some trick will be perpetrated by the scrutiny panel to ensure that the debate does not happen during this term. And that, I say, is vanishingly unlikely. The chair of the scrutiny panel is in favour of assisted dying. There is no secret about that. She wants the law to go through. And the other two members of the panel are equally insistent that the debate should happen during this term. I have made that point on a number of occasions to the Minister. I thought, I must say, that we had reached agreement, or we were certainly very close to agreement with the Minister last week, that the debate would be postponed until the 24th of February, and I don't really understand what has gone wrong. The Minister wanted an assurance that the law would not be called in, and so far as I'm concerned, he may have it. The scrutiny panel will be ready for the debate on the 24th of February. I think, sir, that members need all the information they can have, and that will be available through the scrutiny panel's comments and its amendments, and I think that should be available before the debate on the principles takes place. And I accordingly ask for a postponement of this debate until the 24th of February.
Thank you, Deputy. Is the proposition seconded? Does anyone wish to speak on this proposition to postpone the debate until the 24th of February? Minister.
Yes, sir. I urge members very strongly to reject this proposal. It's easy to use casual terminology like nodding through, and this process won't do justice to the proposition, and I think that's entirely wrong. We had another one where it was said that it was vanishingly unlikely that something would go wrong. But I have to let members know, just in case they don't. I sought an unequivocal written guarantee from the panel that this wouldn't be called in if the debate took place on the 24th of February. Had that been made available to me, sir, we'd have had the debate on the 24th of February. It wasn't. So I'm in a position where I either had to call for the debate to happen today and the detail be debated at a later stage, or risk this being called in on the 24th. And if that were to be the case, this wouldn't be debated within this Parliament. It would be cast forward probably as late as the autumn. It'd have to be relodged, and it would be a different Parliament that considers it. That's not what we promised the public. As far as they were concerned, we indicated that this was going to be dealt with before Christmas. Then we could deal with it on the 20th of January without any problem. then the 24th of February, and there has to come a point where you're doing what's in the best interest of the public to draw a line in the sand. And that's exactly what I've done. And I don't believe this would give scrutiny up until the 24th of March. They've got 4 parliamentary sessions to rely on, and it gives them more than enough time. I'll make it plain that the first draft of this law was sent through, I think, on the 6th of June, and every additional amendment or change that's been made was sent through literally the minute it came out of the printer. So I think that we can do justice to the process, and I urge members very, very strongly indeed to reject this for all the reasons that I've stated. Thank you, sir.
Thank you, Minister. Does anyone else wish to speak on this proposition? Deputy Coles.
Thank you, sir. And I too share the Minister's concern where the proposing deputy referred to this as a nod through. For me, that makes me feel quite uncomfortable because I know there are some members of this Assembly who are very principled in their beliefs on assisted dying, and I believe there are some members in here who will never support assisted dying in any form, and there are some people in this Assembly who will always vote for assisted dying in its forms. So the fact to say that this would be a nod through, I think, is very disrespectful to members who will vote on their conscience, because this is what this vote is going to be, a vote on conscience. My concern, sir, about deferring this also comes in the sense of the scrutiny process. As the Minister again has outlined, you know, that the panel can call this in after we vote on the principles, where they can propose their amendments, and we actually then separate this vote, whether we're voting for the principle of assisted dying in this Assembly this week, and then we come back once the scrutiny panel have got their amendments, and we vote on the articles. We then vote on, if it gets through the principles, we then vote on how that law is going to work. And I feel sometimes, sir, that we get quite confused in this Assembly about what is the principles and what are the articles. Parliamentary process around the world is split, where you have a vote on the principles. It goes to scrutiny. In the UK, that goes to the House of Lords, and then it comes back. So we can take, a law has been agreed that we are going to investigate this further. We're going to work on this on the principle of this law. Then we find out how it works, and then do we agree with how this law is going to work? And that's what, by deferring it and trying to do this all in one day, I feel we are giving ourselves too much rush, too much pressure, and are not actually taking the right amount of time to consider things properly. So, sir, I very much am going to vote against this because I feel we are moving away from parliamentary process in the way that we should, and separating principles, second reading and third reading is the way we should be doing this. And I would also like to see this done before the end of this term, because it was an election promise, and it was a question that kept coming up on the doorsteps during my election campaign, and we deserve the public to have it resolved, whether it is in the positive or the negative, depending on your viewpoint in this. So, sir, I will not be supporting this.
Thank you, Deputy. Deputy Scott.
Thank you, sir. I know that States members were aware of a request from the chair of the panel to have this debate delayed, and in response to that, I had asked whether there could be a bit more of an explanation. I agree with Deputy Coles that we, the States Assembly, should know by now what the approval principles means. The bailiff gave such a ruling, and particularly, I believe, in the context of the residential tenancy law, where on that occasion the scrutiny panel was very keen that the principles would be approved in order that the law could be called in and that they could propose amendments, which of course would be the natural way to go, so that the Assembly could consider the amendments of the scrutiny panel. So my simple question was, could you perhaps just provide some sort of explanation of what is actually so contrary to the principle of this law that we might not just simply do it that way? And I didn't have any written response. It may be that the chair is feeling more able to offer one now, but I come back to this idea that from my understanding of the ruling was that the approving the principle of the law is simply the idea of having such a law, and I believe that the States Assembly has already, if you like, debated that issue. So So I suppose the one other thing I'm thinking, is this some sort of timing issue? It's asking for even more time to produce these amendments, because I don't think actually offering a chart or an explanation that I requested would have taken that long, but that hasn't happened. But if it's a timing issue, is it a resourcing issue? If it's a resourcing issue, I know we've even had a debate about the resourcing of scrutiny, the use of independent advisors, and that should be thought adequate. So, Sir, I'm not persuaded to support Deputy Ballash's proposition for that reason. Thank you, sir.
Thank you, Deputy. Deputy Catherine Curtis.
Thank you, sir. The draft law was lodged in September last year, and the panel has worked very hard on this matter, and I'm extremely confident that we will be ready for the 24th of February. But it is wrong, I think, to give an unequivocal undertaking on any matter of such great importance. While all involved in the production of this law has done excellent work, we must remember how important this law is. It is literally a matter of life and death. Every word matters because there cannot be uncertainties remaining in the law when there is potential for disagreement. As Vice Chair of the Assisted Dying Review Panel, I believed, as did the rest of the panel, that we would be able to conclude the work before the January sitting. However, concerns have arisen during our in-depth study of the law, and so we've had to draft amendments, and despite the extra work put in by panel officers, we cannot have everything ready for this January sitting. I think it would be far preferable to hold a proper debate on this matter in light of any of the amendments being brought by the panel, and I strongly support this deferment.
Thank you, Deputy. Colin Thomas and Saviour.
Thanks, very, very briefly, sir. I've had the privilege of being in this assembly for many, many years. This, I would dare say, would be the most important proposition that's ever come before me. So I will be supporting Deputy Ballash in this. I want to make sure that I have every scrap of information before me before I make judgment, sir. Thank you.
Thank you, Colin Thomas. Liz Morrell.
Thank you, sir. I have incredible sympathy with the situation that the Minister finds himself in because, one, I know how personally passionate he is about the issue of assisted dying. And secondly, I also know what it is to have a key piece of your legislation over your ministerial term come down to this part of the parliamentary term. And I can understand exactly why he is so concerned about a deferral, because the scrutiny panel would still have the right, if we did defer this till February, the scrutiny panel would still have a right to call it in if they were to do so. It could make life very, very difficult for that legislation and ensuring that it is maintained. The only way I can see around that problem, the only way I can see myself supporting Deputy Ballash's proposition would be for the scrutiny panel to give as cast iron assurances as they can with regard to not calling it in, but also bringing their amendments and all their all the scrutiny work they've done to the Assembly by the 24th of February. Without that, I absolutely support the Minister's desire not to have a deferral, because I do understand why he wants to ensure that this legislation is debated, for better or worse, from his perspective, before the end of this Parliament. And I am concerned that a deferral could well lead to that not happening. And I think it's right that this is heard in this Parliament. Otherwise, this legislation will have stretched across three assemblies, so not parliaments. So, thank you.
Thank you, Deputy. Deputy Dublé.
Thank you, sir. I was hoping that we wouldn't have this today, because I was hoping we would have the certainty of proceeding with a vote today. However, I do respect Deputy Ballash's need for wanting to move the debate. I also respect the Minister's views. I can see all sides of this. I think Initially, I did not agree with the Minister's decision to press ahead with the debate today. But as I've said, I do respect it, and I see his need to retain that control over the date of the debate, as I think Deputy Morell so eloquently explained those feelings that a minister might have. I can see that. And whilst we weren't able to acquiesce to the exact wording around the reassurance that was being asked for, I think my Vice Chair alluded to that. We have given repeated assurances that the panel's work will be concluded and a report will be published. In fact, our officers are report writing as we speak today, and I echo the thanks that the Minister gave to his officers. I wish that everybody could see the hard work that is going on behind the scenes. We are incredibly lucky, not just with our advisors, but with the high quality scrutiny officers that we have. I'm incredibly grateful to them, and they are getting on with that work as we speak. So I will repeat my assurances to the Assembly. I'm absolutely confident that the work will be concluded, that it will be a robust and high standard piece of work, and I give my unequivocal reassurance to the Assembly that work will be finalised in time for all three stages of the debate to take place before the election. We're aiming for the 24th of February. I believe that we will meet that deadline. We do have several amendments, I think 9 is the last count. We had 15 that we were considering. The Minister has taken some of those on board. That's part of the collaborative working that we've been doing. And we've got it down to 9 amendments. Again, they're being drafted. Reports are being written for those as we speak. I can't go into full detail about them just now, because of course we do have a very balanced panel with a wide range of views, and things can change, and we do we scrutinise our own work to the level that we want it to be absolutely spot on before it's lodged. But to give a flavour of some of the amendments, we're looking at the third party right of appeal, which would see individuals being able to reveal other people's medical information in court. We're looking at putting the training around prevention of coercion actually into the law rather than just into the guidance. There's some specific wording around that even today I was talking to the drafter about. We are looking at a disability advisory board. We have been looking at the mode of delivery. That's just around half of them that we are looking at. And I would really like to just be able to focus on that work and on completing that work to a high standard. And I understand that there is a decision for members to make, and I feel that that decision is in members' hands today. I will work with whatever the Assembly decide. We can proceed today with the vote if that's what the Assembly decide. Equally, we can carry on with the work and proceed for all three votes on the 24th of February, if that is what the Assembly decide. So the panel are in the hands of the Assembly, and we will complete our work, whatever is decided.
Thank you, Deputy. Does anyone else wish to speak on this proposition? Conatapa St Mary.
Thank you, sir. And I confess that I'm unsure as to the reluctance of members to vote for the principles today. I remind of the situation involving the residential tenancy law, where the Environment Scrutiny Panel were in much the same position. We pushed for the principles, and eventually they were, and those principles were debated on without the benefit of our expert advisor's report. He was an expert. He was a King's Counsel, former Attorney General in Westminster, and it was important that we had his observations and wisdom. The principles were then voted through. Scrutiny continued their efforts throughout the summer. We lodged amendments, and at the end of the day, those amendments were considered and debated upon. And I stand to be corrected, but I'm unsure as to why that situation should not apply here, in the sense that if there are certain amendments which we don't like when it comes to it, then we vote against them. So I do understand the Minister's position, why he wishes to be cast iron sure that the debate will continue, and said to any other comments to the contrary, I will be voting for the principles on the basis that we can look more leisurely at, not leisurely, but seriously at the amendments when they come and take an educated decision at that stage. I shall therefore be supporting the Minister.
Thank you, Tom. Deputy Rob Ward.
Thank you, sir. So it was the 22nd of March 2024 when 31 members voted for, 15 conch and 3 were absent for Part A of the proposition to bring to this Assembly an assisted dying law. I won't read it all out, sir. So we have been through debates before. So I have to say that I have huge concerns, and this is not nothing, there is nothing personal about any issue, any individual involved in this. But I have been on scrutiny. I know the challenges that you face with scrutiny. It only takes one change to somebody, an officer not be there, or a holiday, or sickness, or something like that, when timeframes, if they are very, very tight, get lost. We have heard from one member of the panel that the intention was to get everything by the 24th of January, but it wasn't necessarily able to do that, and there's no unequivocal guarantee that it can be through, and I understand that. And we've heard that we can give as much a guarantee as possible. My concern is that this very, very important piece of legislation that enables people eventually to have control over the end of their lives can be lost in procedural processes. By voting on the principles today, I remind the Assembly, I'm sure everybody knows this, it can then be called in by scrutiny with a set time, and if scrutiny I've obviously done a lot of work because there are 9 possible amendments that exist in the background somewhere. So I can't see why they can't be brought forward quickly and brought to the next sitting of this Assembly, which gives time. Then if those amendments are voted through or not, there is something called third reading, as we all know. And if you are opposed to assisted dying with all of the changes that have been brought forward in those regulations, there is your opportunity to not vote for assisted dying. But we do so as part of this Assembly, who voted for this process to go ahead. And I think it would be really wrong of us to not see this through. And my concerns are, and perhaps I'll make a prediction, sir, that we will get to a point where we end up not debating this for whatever reason. Now, there won't be anyone individual to blame. I'm not saying there are tricks or anything going on, but we know how this Assembly works. And I remind people, and particularly people who've been here for some time, this is my 2nd term, during the end of this term, at the end of this term, all sorts of things get brought forward. There are all sorts of reasons for some things to be opposed, some things to be changed at the very last minute. We've seen that example today. And there is that thing in the background called politics, with an election coming. And I think we need to be incredibly careful in delaying in this way. I think we should vote on the principles today. If those principles are successful, and it certainly won't be a nod through, there will be another significant debate on the principles, and quite rightly, because we need to prove to the members of our society that we have taken this seriously and we've thought about everything as in the principles of this and the reasons why we are voting for or voting against. That then, if that is voted through, goes, the scrutiny panel can call that in today or tomorrow or whenever it is. Do that work, bring those amendments, some of which, me just hearing the background of those, are not hugely significant amendments and may be agreed with. They may be agreed with by the Minister and say, yes, we can make that change. Yes, that's not a problem. And then when they are voted for, the third reading is the position to strongly express your opposition, if you have opposition, and vote against this before we go to the election, so we are clear with the electorate. So I urge members, please do not delay this. I think we are creating a significant risk, and I don't think that's right, I don't think it's fair, and I don't think that's what we are elected to this Assembly to do. I urge members, please do not support this. Let's vote on the principles during this sitting.
Thank you, Deputy. Deputy Renouf.
Yes, sir, a couple of small points, maybe. I do think, I agree with those people who say that the problem with the delay is that essentially we have a deal with the public on this. If the work to prepare the legislation had not been done, or had not been done well, then we would be justified to delay debate on the principles. But as far as I can see, the work has been done with exceptional diligence and exceptional care, and I commend the Minister and his team for that. So I have sympathy with the Minister's point that he cannot delay without a guarantee, and I also have sympathy with the inability of the scrutiny panel to offer a cast iron guarantee because no one can be sure. There are circumstances in which the timetable might be thrown out of kilter. We don't know what they are. That's the nature of black swan events. But international affairs certainly gives us pause for thought about that. So I think the Minister is right to say, let us make as much progress as we can to make sure that this Assembly does get to make a decision on the legislation on assisted dying. And my second point, I think, is that I've not actually heard a single substantive point of dissent about the principles. No single substantive point has been raised to say why we might not want to consider the principles today. It is, if you like, a point of principle not to discuss the principles. It's an abstract point, but I cannot see that it has substance. And Deputy Balash has said that we should not divide it up into two parts. And my point is, why not? The principles are a different matter to the articles. I do not think that we have to see all the amendments before we debate the principles, and several members have made allusions to when that has happened in the past. And I honestly cannot see that it is a huge test of our abilities to have separate debates on principles and the articles. So I am content that the principles of the law could be debated today with no risk to the, if you like, safety of that decision, regardless of the fact that we haven't seen the amendments yet. I think there might even be some merit in it. It separates the two issues, as indeed happens in many, many parliaments as a matter of routine. And I don't see it as a huge risk, and for that reason I will not be supporting Deputy Balash's proposition.
Thank you, Deputy. Deputy Luce.
Well, thank you, sir. And I rise just to support Deputy Renouf, Deputy Ward, Constable of St Mary's, and say that I too can't see any reason at all why we shouldn't debate principles today. I particularly want to agree, sir, with Deputy Tom Coles, who made the point about the public view, and where I agree that on the doorstep it was an issue, and where we have asked the population of this island, over 3/4 have indicated that they want this choice. So I want to be able to be in a position to push a pour button in favour of giving islanders that choice. And the only way I can be guaranteed to be able to do that is to debate the principles today, so that we can have, whatever happens, a debate on this second and third reading before we close the session of government. Thank you, sir.
Thank you, Deputy. Does anyone else wish to speak on this proposition? I call upon Deputy Balash to reply. Deputy Balash.
So this is obviously a matter for members. We as an Assembly are bound by rules, and there is only one way in which the assisted dying law can be pushed over until the next states, and that is if members choose to do that. Members have heard from the 3 members of the scrutiny panel who have assured the Assembly that we will be ready by the 24th of February, and that there is accordingly no intention to call in the bill after the debate of the principles, assuming the principles are adopted. I think there is something to be said for appearances, and I think it would not give the right appearance if this Assembly were to push through, driven by those who want to approve the principles, in debating or starting to debate this law until all the relevant information was before the Assembly. All the relevant information is not here, and it would be unfortunate, in my view, if we were to press ahead and debate the principles in these circumstances. I maintain the proposition and I ask for the appel.
Appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. All members have the opportunity of casting their votes. I ask the greffier to close the voting. As the proposition has been rejected, 14 votes for, 31 votes contra, and 1 abstention. Yes.
Those members voting for the Connétable, St Helier, St Lawrence, St Bellard, Trinity, St Clement, St Juan and St Saviour, and Deputies Gorst, Banash, Catherine Curtis, Howell, Kovac, Barbara Ward and Wilson, and Deputy Doublé abstained. Now move on to the draft assisted dying law. I'll ask the greffier to read the citation. Draft Assisted Dying Jersey Law 2000, a law to provide for the assisted dying of someone who has a terminal illness, who has experienced or is expected to experience unbearable suffering, and who chooses to end their life with the help of a medical professional. The States, subject to the sanction of His Most Excellent Majesty and Council, have adopted the following law. Minister.
Sir, by way of introduction to the debate on the draft assisted dying law, I'm going to risk stating the obvious by reminding members that this will be a debate on the principles of the law, one that's primarily intended to confirm whether we should continue to move forward in order to consider the provisions of the draft law in detail. So as much as I do have a number of points that I have to make, I will be as brief as I can, because we already know that in November 2021 and again in May 2024, this Assembly agreed in principle that assisted dying should be permitted in Jersey. We've also agreed the key provisions to be set out in that draft law. And I think it's safe to say that should we not agree to continue to the second reading with a debate on the provisions taking place at a future date, we would, I'm sure, damage many islanders' confidence in the Assembly and the wider democratic process. Put simply, the draft law seeks to provide terminally ill islanders a degree of control over the manner and timing of their death. It's about both dignity and choice. And in providing choice for those who want it, the draft law also brings forward a robust framework of controls to ensure that the safety of islanders and professionals is maintained. In terms of structure, there are 4 key pillars to that draft law. Firstly, it sets out the assisted dying process in detail. The provisions of the law are comprehensive, covering the processes associated with request, assessment, approval, and the provision of assisted dying. Secondly, the draft law sets out the multitude of safeguards and protections for islanders seeking an assisted death, as well as support and protections for their family and loved ones during the process. Thirdly, the draft law provides protections for our health and care professionals, regardless of their views on the matter. The law, as drafted, supports both those who choose to opt in and work for the assisted dying service, and those who choose to exercise their right to refuse and not participate in any aspect of the law. And finally, it details the considered oversight and regulation of an assisted dying service. It provides the checks and balances necessary for a safe law, including the creation of an independently chaired Delivery and Assurance Committee, a separate review panel that examines each and every assisted death, and independent regulation and inspection by the Jersey Care Commission. The draft law, presented by the Council of Ministers, is the culmination of over 5 years of work. 5 years of consulting with the public, with on-island health and care professionals, and with key stakeholders, including professional regulatory bodies, the General Medical Council, and the Nursing and Midwifery Council, to name but a few, and the bodies that represent those professionals, including the British Medical Association. We've also spent 5 years looking at experience and best practice in jurisdictions that already permit assisted dying. We've examined how those jurisdictions protect people and where they fail to do so. It's been noted that this draft law most closely resembles assisted dying legislation in Australia, where laws have been in effect for almost 7 years. Yet little of the Australian experience is discussed in our media or reflected in the wider assisted dying debate. Perhaps their safe and measured approach to assisted dying makes it somewhat less newsworthy than headline-grabbing stories from Canada. Like us, the Australian legislation was government-led and brought following years of considered policy development. As a result of this long period of policy development, our draft law has safeguards hardwired throughout. Safeguards that are so numerous, I will not recount them now in detail during this debate on the principles. That will be for the forthcoming debate, except for drawing your attention to two key matters. The first being that the safeguards work to ensure that only islanders who meet the eligibility criteria are approved for assisted death and actively protect against a person being coerced into having an assisted death. The draft law expressly requires assisted dying professionals to be trained to identify potential coercion in its many forms, including its less viable forms such as coercive control and financial abuse. They'll be looking for it actively. The law also requires the assessing doctors to talk expressly about possible coercion with the individual requesting assisted dying and to satisfy themselves that the person's decision is voluntary, not just at each individual step in the process, but also between those steps. Assessing doctors will be supported in this task by a multidisciplinary team consisting of nurses and social workers and other professionals with experience and knowledge to complement the doctor's skill set. Further to this, the law enables the assessing doctors to seek relevant opinions from others, such as family members or the family GP, to support their determination. And should coercion be uncovered, the law creates an offence of coercively inducing a person to request assisted dying, with a maximum penalty of 14 years imprisonment. This draft law certainly doesn't take the matter of coercion lightly, sir. The second example of how the safeguards within this law come together to protect those involved in the process are the significant protections for professionals. Under the draft law, not only do all professionals have the right to refuse to participate in assisted dying for any reason, but those professionals are also protected from potential adverse treatment. This would apply in the case where they were dismissed or denied promotion on the grounds that they chose to refuse to participate in assisted dying. The law also requires that support, training and guidance is made available to all health and care professionals on island, not just those who opt in to work for the service, but all those whose patients may consider requesting an assisted death or may want to talk to trusted carers about their choices at end of life. So, as I approach the end of this introductory speech, I'd like to thank the Assisted Dying Review Panel for their efforts in ensuring robust scrutiny on the draft. Having had discussions with the panel chair, I understand that they'll be lodging some amendments for our future consideration. And as stated in the briefing to members last week, following continued engagement with the panel and key stakeholders, I'll also be presenting some minor clarifying amendments to the draft law, none of which will change the underlying policy or divert from the previous decisions taken by this Assembly. They will simply serve to clarify the wording and intent of the draft law. Since we last debated assisted dying in May 2024, the position on assisted dying within the British Isles has shifted. The Isle of Man has passed their assisted dying bill in March last year, Scotland's bill continues to progress to the third and final stage, and the UK bill has moved successfully through the House of Commons and is undergoing consideration by the House of Lords. So what we're doing here is not unique, but it is of unique importance. It is complex and it is difficult, but all important things usually are. We know that not everyone is in agreement with the principle of assisted dying, as is their right. but I'm confident that the decision taken by this Assembly back in 2021 to permit assisted dying in Jersey was the right decision and is supported by the majority of Islanders. As elected representatives, we now need to honour the decision that was made with our strong support of P18 2025 and agree to adopt the draft law in its first reading so that we can commence examination of the draft law. To fail to do so would be a disservice to the island, sir. So I'd now like to propose the principles of this draft law. Thank you.
Thank you, Minister. Are the principles seconded?
Yes.
Conor Thompson-Helier.
Thank you, sir. Since the debate on the principles in November 2021, I have experienced a number of testimonials from people who have been involved in the death of people, their friends and relatives. And what has struck me about them is that in spite of the safeguards the Minister is talking about putting into the bill, human nature doesn't change. And I have heard of some truly harrowing accounts of how the relatives in particular have argued over wills, and the pressure that has been put on family members about their upcoming departure from this life. Now that may not sound particularly relevant to this debate, but I think what it has shown me is that the pressure that will be put on a person who is in the last stages of their life can be truly intense. And I don't believe that the safeguards that are being built into this law can stop that, because it is, as I say, human nature. You only have to think back to some of the Victorian novels which are so preoccupied with these kind of matters, and some of the experiences I've heard about are truly Dickensian, and what a pity they weren't confined to the pages of a Victorian novel. The other point I wanted to make, sir, is that since the first debate, which I did not support for reasons of principle, I have had close experience of two members of the public who have died after long terminal illnesses. The first I've been aware of for some time because it's gone on for about a decade, much longer than the partner of the person concerned or I, as their constable, thought was possible. And this person telephoned me after the last time I voted against the principle in tears, and they wanted to express their gratitude that I had voted against assisted dying. And they said for them, in spite of the stories you hear of difficult deaths, the fact that their partner could not choose assisted dying meant that they lived far longer than either they or their partner expected, and indeed they were alive for their daughter's graduation from university. The second example, one which was much closer to me, involved a person who was in the final stages of dying and receiving excellent palliative care at Orchard House. And I want to put on record my heartfelt thanks to that organisation, those staff who treated this person so well. And in their dying hours, I was able, because I was at their bedside, to put in a phone call to a close relative of theirs. And although they were effectively not responding to any stimulus, when they heard the voice of their relative on the telephone, it was quite clear from the way their body reacted, certainly their mind had closed down, but it was quite clear that they had heard that message of love from their relative. And I was so glad that they were not denied that, and that their last experience on earth was to hear the love of their relative expressed through the telephone. Now for me, those two experiences, those two testimonies, if you like, mean that I haven't changed my view about this. I think the risks are still there, and I think that it is simply not something that we should be pursuing at this time. So I will be voting against the principles. Thank you, sir.
Thank you, Conor Tarr. Jyoti Ferry.
Thank you, sir. So today we again consider one of the most profound questions that any society can face. how we respond to suffering at the end of life, and whether we allow individuals the right to choose assisted dying under carefully regulated circumstances. The Ost-Mullock-Preston report on Jersey's assisted dying law, which I thank the chair of the scrutiny panel for, provides us with a thoughtful, rigorous framework. It reminds us that it is not simply a legal matter, but a moral and human one. It is about dignity, compassion, and the balance between autonomy and protection. At the heart of this debate are people, our neighbours, our friends, our loved ones who face unbearable suffering from terminal disease or degenerative conditions. For them, the question is not abstract, it is immediate, personal, and in some cases, painful. Assisted dying is not about diminishing life, it is about affirming the value of choice, the importance of dignity, and the recognition that sometimes, despite the best palliative care, suffering cannot always be alleviated. The report makes clear that assisted dying is not intended to replace palliative care, but to complement it. It is a last resort, available only when all other avenues have been exhausted and when the individual, fully informed and capable, makes a voluntary decision. Let's not forget that the law sets out strict eligibility criteria, so only those adults over 18, only those with a terminal illness or unbearable suffering from a serious condition, and only those who have lived in Jersey for the last 12 months. 2 independent medical assessments are required, a mandatory reflection period is built in, and capacity must be confirmed. These safeguards are not incidental, they are central. They ensure that assisted dying is never rushed, never coerced, and never applied to those who are vulnerable or unable to decide freely. The report rightly emphasises the importance of oversight. An independent monitoring body will review every case, ensuring transparency and accountability. This is how we protect both the integrity of the law and the trust of the public. We are not the first jurisdiction to face this question. Canada, New Zealand and Australia have already introduced assisted dying laws. Their experience shows that with strong safeguards, assisted dying can be implemented safely and ethically. The report draws on these examples, adapting them to Jersey's context. It recognises that our island has unique needs, but we can also learn from others. Importantly, it notes that assisted dying has not led to the erosion of care or abandonment of vulnerable people. The ethical case for assisted dying rests on 2 pillars: autonomy and protection. Autonomy means recognising the rights of individuals to make decisions about their own bodies and their own lives. It means respecting the deeply personal choice to end suffering when no other relief is possible. Protection means ensuring that no one is pressured, coerced, or left vulnerable. It means building safeguards that are strong, transparent, and enforceable. The report shows us that these 2 principles can coexist. We can uphold autonomy while protecting the vulnerable. We can offer choice without compromising safety. Of course, passing the law is only the beginning. Implementation matters. The report highlights several practical needs. Training for healthcare professionals so they can support patients with compassion and clarity. Guidance for pharmacists and medical staff, ensuring that procedures are safe and consistent. Public information campaigns so that everyone understands their rights and safeguards and the process. Administrative systems to manage applications, approvals and reporting. These are not minor details. These are the infrastructure of trust. They ensure that assisted dying is not only legal, but workable, transparent and humane. The report makes several recommendations to strengthen the draft law, enhance safeguards to reassure the public, ensure robust oversight and transparency, provide adequate funding for both assisted dying services and palliative care, monitor outcomes closely in the first 5 years of implementation. These recommendations are not obstacles, they are opportunities. They allow us to build a law that is not only compassionate but credible. They ensure that Jersey leads with dignity and responsibility. We must also recognise the broader social context. Assisted dying is not simply a medical procedure, it is a statement about who we are as a society. By introducing assisted dying, Jersey would become the first jurisdiction in the British Isles to do so. This is a significant step. It signals that we're willing to confront difficult questions with honesty and courage. It shows that we value compassion, autonomy and dignity. It also demonstrates that we're willing to learn from others, to adapt best practices and to build a law that reflects our values as a community. So, some will ask, does assisted dying risk pressurising the elderly, people with disabilities or the vulnerable? The report addresses this directly, with strict safeguards, independent assessments and oversight. The risk of coercion is minimised. Others will ask, does assisted dying undermine palliative care? The evidence from abroad suggests the opposite. Assisted dying often strengthens investment in palliative care as societies recognise the need to support all end-of-life choices. Still, others will ask, does assisted dying devalue life? I would argue that it affirms life. It affirms the value of choice, the importance of dignity, and the recognition that suffering should not be prolonged against a person's will. Sir, the Oss-Mullock-Preston report raises some really interesting points, but we already have a clear path forward. Assisted dying can be introduced safely, ethically and compassionately, reminding us that autonomy and protection can coexist. It challenges us to lead with dignity, to balance choice with care, and to ensure no one is left to suffer needlessly. This is not an easy decision. It is one of the hardest we will ever make, but it is also one of the most important. By supporting assisted dying, we affirm our commitment to compassion, dignity and respect. We recognise that sometimes the greatest gift we can give is the freedom of choice. Let us demonstrate that Jersey can offer choice and protection hand in hand. Sir, I will be supporting the principles.
Sir, may I have a point of clarification, please?
If you're prepared to give way to that.
Yes, sir.
Yes.
Thank you. Yes, it was just to ask, in the Deputy's speech, he said that Jersey would be the first in the British Isles to bring forward this law. I just wanted him to clarify that that is not necessarily a positive in regard to this legislation.
It may not be a positive, but it was a statement of fact, sir.
Thank you. Deputy Chief Minister.
Thank you, sir. I rise to support the proposition as I've supported the principle in previous Assembly debates. So this proposal is a result of a deliberative and transparent process that has engaged islanders, clinical experts, ethical reviewers, and of course this Assembly. At its core, this law provides a clear and structured framework for individuals facing a terminal illness to make autonomous decisions about the end of their life. It recognises the importance of personal agency in deeply sensitive circumstances while ensuring that stringent legal and clinical safeguards are in place. The draft sets out a rigorous pathway. Eligibility is limited to adults with a prognosis of short remaining lifespan and assessed capacity to make informed choices. Multiple layers of assessment, including independent review and judicial appeal. Rights are or could be prevalent. This Assembly's previous decision and the extensive public engagement demonstrate that islanders demand both careful protection and choice. The proposition responds to that mandate by balancing autonomy with oversight, reflecting international practice and respecting Jersey's particular social context. I'm not sure whether it's important, whether the first or the last or indifferent. It's important that we do it in relation to our social context. Importantly, the draft law protects healthcare professionals. Participation is voluntary, and no clinician or institution will be compelled to act contrary to their professional judgment or conscience. Professional support, training and regulatory oversight are also part of the preparatory work envisaged before implementation. I think it's worth just briefly running through the key points to refresh memories. I had to do it myself because it has been some time between the debates of the principles and where we are now. The law has been developed following multi-stage public engagement and consultation process, assistance, jury, and ethical review, prior States Assembly decisions to proceed to law drafting for assisted dying, sir. The draft sets out eligibility, process steps, safeguards, oversight arrangements, professional protections and regulatory mechanisms. It applies to adults with a terminal illness, limited life expectancy, generally under defined timeframes. Individuals must have decision-making capacity, a voluntary informed request, and be ordinarily resident in Jersey. These criteria aim to ensure clarity and focus on a specific, well-designed cohort. Multiple stages of assessment by qualified doctors, including independent review, minimum timeframes, and opportunities for withdrawal at each step. Robust documentation, appeal routes, independent oversight through the assisted dying assurance and delivery committee and regulatory review. As I said, sir, no healthcare worker or institution is compelled to participate. Protections are provided from unfair treatment for those who refuse involvement on conscience or capacity grounds, sir. There will be regulation, ongoing data reviews, and operational guidance, sir. So I speak, sir, as somebody who sat at the bedside of both parents and watched them die slowly and painfully, sir, in an instance. And I urge members to support the principles of the proposition. Thank you.
Thank you, Chief Minister. Deputy Barbara Ward.
Thank you, sir. Back in May 2024, I spoke at length my views on the aspect of assisted dying. I described, my description of that was based on my 45 years of working in healthcare facilities. And I couldn't support the introduction of assisted dying, which still remains today. Especially if it includes the waiver element that, in my opinion, purports to be a form of involuntary euthanasia. That being because the patient is unconscious or has lost capacity and has not got the right to express yay or nay to their passing. My view is goes against the belief system and my professional code of practice, embraced in my codes of practice, which are set out in the UK registering body, the Nurses and Midwives Council, and these being prioritise people, practice effectively, preserve safety and promote professionalism and trust. Yes, as health professionals, we have assisted patients nearing their end stage of their life's journey via palliative care and the appropriate pain and anxiety legally prescribed medicines. May I say, sir, that for me personally, it's been a privilege to be part of a patient's end of life journey by ensuring the patients in my care had a peaceful, serene, pain and anxiety free, to the best of our ability, passing with appropriate medication and compassion. My heart goes out to people who have sadly experienced some of their loved ones uncomfortable passing, but that may have been due to the lack of training and proper prescribing and medication at that time, sir. But that has not been my experience as a professional nurse during my career. What this debate is about is the dispensing, delivering and administering a cocktail that one knows is highly poisonous and will kill the patient, and that worries me greatly, especially if that patient is unconscious or has lost capacity. I have to say, sir, that early on in my career, I attended St Christopher's Hospice that was set up by Dame Cecily Saunders, who sadly died in 2005 of breast cancer. Dame Cecily, in 1967, founded the first modern St Christopher's Hospice in southwest London, and more than anyone else was responsible for establishing the discipline and the culture of palliative medicine and care, and which has been established worldwide. She introduced effective pain management and invested that dying people needed dignity, compassion and respect, as well as a rigorous scientific methodology in the testing of treatments. She put paid to the notion that dying people should wait. She put paid to the notion that patients should wait until their painkillers had worn off because they received another dose, and scotched that notion that the risk of opiate addiction was an issue in her pain management. Dame Cecily Saunders introduced the concept and belief that total pain included the physical, emotional, social, spiritual dimensions of distress. She regarded each person, whether a patient or staff member, as an individual to the end. I was so inspired by this visit and interaction that Dame Cecily's teachings on palliative care approaches have been with me all my career as a bedrock on which to practice, and very much shaped my thinking at all stages of a patient's health journey. Whether a person has cancer, physical or mental health disabilities and suffering. So it's all about how we help patients manage their health journeys. And I'm sure that Dame Cecily will be pleased to have heard with our last proposition, at the end of life care, that we have supported that. She will be absolutely delighted that we are going to embrace palliative care and proper end-of-life investment and care in our health management. So I cannot support the proposition as set out, as I believe it's wrongly titled. In my view, this should be titled Assisted Dying and Euthanasia Law. We need to be honest and transparent. If this proposition is passed, we'll be saying to staff that they can dispense and administer lethal cocktails to end a patient's life. I've searched my conscience and had sleepless nights deliberating the pros and cons, with the conclusion that this is not assisted dying, but assisted suicide and euthanasia, by bringing the end to a person's life, especially if that person is unconscious or has lost capacity, but are still given the injection. For me, there are too many issues around the lack of safeguarding, and I think there are some really increased risks and coercion. So we should be investing in our focus on the living by way of improving patients' quality of life at all stages. And to a certain extent, we spoke about that when we discussed the end-of-life debate. It's about improving palliative care approaches to enhance the quality of life of patients, and that their families who are facing challenges, approaches with life-threatening illnesses, whether physical, psychological, social, or spiritual. The quality of life of caregivers improves as well. Ensure health system policies that integrate palliative care services into the structure and financing of healthcare systems at all levels of care. Palliative care is just not about the dying. Palliative care is a serious concept throughout our health journeys. Ensure there are policies for strengthening and expanding human resources, including training of existing health professionals, embedding palliative care into the core curricula of all new health professionals, as well as educating volunteers and the public. We also need a medicines policy which ensures the availability of the essential medicines to manage severe pain and anxiety symptoms. We have a lot more research and better drugs these days than what has happened in the past, and I'm sure because of the lack of proper medicines at that time, this is when people have experienced some really traumatic and painful observations. In particular, opioid allergies for the relief of pain and respiratory distress. Controlling such symptoms at an early stage is an ethical duty to relieve suffering and to respect a person's dignity. Palliative care is explicitly recognised under the human right to health. It should be provided through person-centred and integrated health services that pay special attention to the specific needs and preferences of an individual. Sir, my conclusion is, I must stand by my principles. Therefore, I cannot support this proposition, and I urge members also to reflect and reject this proposal as presented. I thank you, sir, and members for listening. Thank you.
Thank you, Deputy. Deputy Scott.
So if there's one thing I'm sure of in this debate, is that every member is going to vote with their true conscience in terms of their ethical position and their understanding of what humanity is and should be. And our own experiences are very much going to inform that judgment and how we interpret those experiences. I note that the Constable St Helier mentioned how somebody thanked him that her partner was not given a choice. And I have experienced so many people die on me, people who I've loved. One of them was my mother, who suffered from an illness and took the choice of taking her life. Because she had that choice. And she did it furtively because she wasn't allowed that choice. And family didn't know about this, no consultation. So I'm just presenting the other side of the coin, sir. My father, well, at the age of 17, he signed up to join the army and go to war. And nobody was saying to any of those young men, don't go in a situation where you're going to kill yourselves. So we have a sort of strange kind of, you know, we've felt very strangely, it seems to me, as a society, in terms of what we think is acceptable, in terms of the choices people make. And we can praise them for putting their lives and more or less putting themselves in a way that they could well be killed. We could even, for such a long time, have supported capital punishment and thought that was acceptable. And then there is this position where so many of us have actually seen people who we love suffer at the end of their lives. And that's despite the efforts of some incredible people who've been caring for them, but there are limits. So I might well point, or at least refer to one relative who had Parkinson's, who really did not have a great quality of life, who when he had an incident happened to him and was taken away, actually said to his son, no, it's not long now, and he almost like was celebrating it. And when he was in hospital, actually tore the feeding tubes from his mouth and had a sign above his bed, nil by mouth, after that, because he had made a choice. But this was not an ideal situation, not great for the family to witness, because nevertheless they had to watch that individual waste away. And my brother, who suffered from cancer at quite a young age, and I remember that, again, he was in the care of nurses who cared after him so much, and there he was wasting away, and to the point where he had one of those cushions because he more or less was a living skeleton, and really doped up to manage that pain. And I remember it, but in a way where he couldn't communicate, and yet when he was being moved by nurses, I could hear him whispering, ouch, ouch. So we talk about pain management. And I think there should be more choices in terms of pain management. We talk about family, but the actual, I come back to my father again. I actually had medical professionals come to me and say, oh, we've actually had a discussion with your father about how he wants to manage the end of his life and would he want to be resuscitated. And at the time I was with his granddaughters, and they said, you know, he's of a certain age, and he's actually agreed that, you know, he's lived a wonderful life and he wouldn't want to be resuscitated. And I actually knew. I expected my father to have this attitude. He'd gone to war. He'd always been very sanguine about death. But I just said to these practitioners, well, he is a bit deaf. Are you sure? Let me ask him. And there I asked him in front of his granddaughters, and his reply was, life is sweet. And I thought, right. And I turned around to the medical practitioners and I said, well, there seems to be a bit of a kind of incongruency between what he said and this thing. But even now I wonder about that, because the fact was he was with family. Did he not even want his granddaughters to witness this kind of thing? Or was it just the fact that we were with him and that he thought, well, just a few more hours with us and all that sort of thing? And indeed, there had been situations where my sister had almost like goaded him to continue to actually say, we will come and see you, we will come. But, you know, a kind of form of bribery to just say, no, don't go yet. So it's a very, very complex subject, isn't it, sir? But at the end of the day, what are we really talking about? It's this idea about where choice sits in this society, whether it's in the biblical nature of God has given us choice and how we should use it and whether we should support people in it. And it's this idea of humanity and the way in which people should be allowed to have choices, the way in which pain can be managed. And what I have been really, really impressed about in the development of this law have been the government officers who have actually been involved in developing it. I have really been impressed by their compassion, by their professionalism. And I'm afraid she's not in the chamber at the moment, but I'm also really quite confident in the chair of the scrutiny panel, because I may not agree with her on politics in every way, but she has always struck me as an incredibly ethical and compassionate person. So on this basis, I will be supporting the principles in the confidence that it is going to be adequately scrutinised, in the confidence that we have a society that will support in every way this idea of love and humanity when we are dealing with others. Thank you, sir.
Thank you, Deputy. Deputy Balash.
Sir, I have wobbled, I confess, on this issue over the past years, because I understand the argument for autonomy, but we have no control over the way in which we enter this world, and I'm not sure that it's right for us to seek to assert a control over how we leave it, but that's a personal view. I have three objections to the principles of this bill. The first objection is that I don't believe that the state should be involved in the process. The duty of medical people is to preserve life or to alleviate pain and suffering for those who are dying. Their purpose is not to kill people. The essence of the Hippocratic Oath is to do no harm to your patient, and I understand that some doctors would argue that putting an end to suffering is not causing harm, and I do respect that point of view. But I'm speaking not of individuals, but of institutions. A hospital is a place where people go to be healed. If patients know that once you are in a hospital, you are in a place where your life can be brought to an end, that could be very worrying to some people. Of course, we know that you have to sign forms and persuade doctors that you want to end your life, but for those who are old and vulnerable, the change in the nature of what happens in hospital could leave some to feel unsafe and at risk. When a doctor approaches with a syringe, is he about to give you something therapeutic or something more lethal? And I think I prefer the Swiss approach. There are places where you can go if you want it to end your life. That is the avowed purpose of such places. There can be no confusion of functions. There are no doctors looking after you and trying to heal you, and others whose function is to end life. It is all crystal clear. You are there because you want your life to end. There should obviously be safeguards to ensure that you are not taken there under coercion and that your wish to die is voluntary, clearly expressed, settled, and informed. The second objection follows from the first, that is the state's involvement in the process of dying, assisted dying. The consequence of the state's involvement is the creation of a huge bureaucracy which is disproportionate to the number of people in a small nation like ours who will in practice seek an assisted death. We are going to create an assisted dying service in the hospital. We will have coordinating doctors, independent assessment doctors, assessing doctors, administering practitioners, certifying doctors, care navigators, pharmacists, pharmacy technicians, as well as other healthcare professionals, all needing to be registered with the service. There will need to be training and refresher training for all those professionals. There will be disclosures of interest and a disclosure, an interest review officer. And then the committees. There's to be an assisted dying assurance and delivery committee, a substantial body of between 7 and 15 persons, all to be paid remuneration and to receive expenses. And no doubt many having to be imported from the United Kingdom. It supervises the assisted dying service, that is Health and Care Jersey, and has very wide functions. It will have a lot to do. They produce operational guidance for all the professionals on at least 13 different topic areas. It also arranges general guidance. It will have to produce a number of reports for the Minister every year. That is the Assurance and Delivery Committee, and I have not really done justice to its multifarious functions. I will not recite all the things that the Assisted Dying Service will have to do, but there are many. It will produce 2 more documents on information, guidance and competencies. In addition to the Assisted Dying Service and the Assurance and Delivery Committee, we will have the Assisted Dying Review Panel, also paid remuneration and expenses, which will have its terms of reference set by the Minister after consultation with the Care Commission. Then there is the subordinate legislation. Regulations may be made for independent advocates, safe access zones and their definition, and at least 20 other topics. Ministerial orders may be made, and no doubt will be, on many other matters, as well as rules of court. The bureaucracy involved in this law is really substantial. The recurring annual costs of the law have been estimated by the department as rising to £718,000 by 2029, but that seems to me very optimistic and does not take account in any event of costs elsewhere in the administration. The number of people to benefit from this law may be very small. In England, the House of Commons estimated the number of people who would seek an assisted death under their proposed legislation. Converting those figures to a population of Jersey's size, one arrives at a range of less than 1 in the first year to 7 in year 10. Maybe the figures in Jersey will be higher, but it is still a huge investment for a relatively small number of people. Putting a monetary value on issues of this kind is, of course, difficult. The real point that I want to make is that it is possible to achieve the policy aim at considerably lower costs. Much of the work that has been done, if the principles were rejected, would not be wasted if Jersey were to adopt a Swiss-type system, essentially devolving assisted dying to the private sector, subject to strict statutory control. And the third objection is one which has been voiced by others already, in particular the Constable of St Helier and Deputy Ward. I do not believe that it is possible to rule out the risk that an elderly person will not be coerced into seeking assisted dying, and that coercion will not come to light. The consequence is that the risk is that someone who does not really want assisted dying will be put to death. I have a view in relation to the death penalty, which is that I oppose it because I know that one cannot be sure that courts and juries will not make mistakes and that an innocent person will not be convicted. And the prospect of an innocent person being condemned to death is a possibility that I personally would not accept. And I think it's the same with coercion. There is a risk that if we bring in assisted dying, some people will die who do not wish to die. And for me, I think that is a bridge too far.
Thank you, Deputy. Deputy Miles.
Thank you, sir. I just wanted to put on record a few words to outline my position. My support for this draft law stems from my belief that assisted dying is about embracing compassion, respecting autonomy, and recognising the limits of medicine. It's about providing a humane option for those who face terminal illness with no hope of recovery. I believe that individuals should have the right to make the same deeply personal decisions about their own deaths as they do about their own lives, supported by rigorous standards and ethical medical practice. Now, this doesn't mean that I will support the draft law in its entirety unless all of the safeguards are in place. But from my reading, the draft law is well thought out, and the safeguards presented currently do satisfy my concerns about support for the vulnerable at this point in the process. I acknowledge that the Assembly has not had the opportunity to consider the full scrutiny panel review, nor any amendments that they may bring, and I shall consider those carefully. Notwithstanding, I shall be voting to support the adoption of the principles today, and I will more fully address the articles at second reading. That's all I have to say. Thank you, sir.
Thank you, Deputy. Deputy Tadea.
So I'd echo what the previous speaker has said, and some will say it much more eloquently than I would, sir. So this is clearly, again, not the first time we've had the debate, but it is, of course, something that's deeply sensitive. That's also had a lot of thought already gone into it, and which a lot of thought will continue to be given to it. And this is, of course, also an issue of conscience. Members ultimately will vote with their consciences, which should include voting with their hearts and their heads, sir. That doesn't mean, of course, that we should shy away from debate. It doesn't mean that we should shy away from challenging members when we believe that they've made points that are perhaps not as valid as others, and which, in some cases, I think, are not entirely correct, or indeed may be scaremongering, sir. I would hope that we would avoid those kind of arguments, because there are enough things that we can disagree on at perhaps a fundamental level without introducing spurious ones, sir. When I heard the comments of Deputy Balash outlining what seems to be a litany of reasons why we shouldn't do this, about the levels of bureaucracy that are being created, I would simply say that those one man, one woman's bureaucracy is another member's safeguards, and actually everything that Deputy Balash has outlined there, these bodies that we're going to be setting up, these rules and regulations and the oversight, is exactly because the Minister, and I believe the scrutiny panel, and all of us know that if we are to implement assisted dying, which deals with the very thorny issue of autonomy versus protection against abuse, when it comes to what is, I think, in many ways we'd all consider the sanctity of human life, whatever we mean by that, is that this is what these safeguards are there for. So you can call it bureaucracy, we can talk about the costs, and we can talk about the fact that this may benefit only a very few people. That when someone says only a very few people will benefit from this law, I don't think that's true. I think we all will potentially benefit from this law, not because we're going to use it, but because it's there in the back pocket. And we've heard that in so many testimonies from people who say that my partner, or indeed when they're going through it themselves, they say, I never ended up using it in the end, but knowing that it was there, or the thought that it would have been there if things had got too much, if the pain had got unbearable, that simply having that option there was sufficient to get me through. And I think that's what will be the case for so many people, and I don't think you can put a price on that. And the question I would ask to those members who validly stand up and say, look, I can't support this because we're asking the medical profession to do something that goes against their oath or what I see as their job, I would say to them, what's your alternative? What are those members proposing to actually say to the many people in our society who want to have that ability and that choice at the end of life? What is your model that you're proposing? Is it simply to say, this is my belief system, and it's fine to have your own belief system, but we're not here to impose our belief systems onto other people, and I think that's what it ultimately boils down to, sir. We hear about some people maybe being condemned to death. Have we ever thought about the slightly more abstract and converse notion of being condemned to live a life that you no longer wish to live? So being condemned to life. Because that's what we're saying to people. If we don't give them this option, people who can no longer tolerate living, who have come to peace with the end of their lives, who have made peace with their family, and whose families are also in a position where they're ready for them to go in a dignified way and in a controlled way, we're saying, no, we're not going to let you have that, because there's a potential for an abstract abuse, either in reality or in the abstract, that somebody somewhere might be abused. And I would say that actually the abuse can work both ways. We hear the stories, which I think are well understood, that somebody might try and bump somebody off simply to get an inheritance. But I've actually seen people who are, and I deliberately use the quotation marks there, those are words that I've heard, but we don't focus on the, I've seen examples in the past where people have actually are quite happy that their relatives are still alive because they've been misappropriating their money. They're quite happy when the elderly mother is in a care home for years on end because actually they've got access to their accounts and they're using that money to fund their lifestyle where the mother isn't getting that money. So there can actually be a counter pressure to keep people alive because, of course, when they're alive, the money's often coming in. There's also the difficult question we have about the very lucrative care industry and that we have in Jersey, where people are paying £6,000 a month often, maybe more, for questionable quality of life. And that's why I very much welcome what the ministers, what we've passed earlier to do with the care model for the end of life and for palliative care, sir. These things do need to be considered in the round, sir. There was also talk about people dying in hospital and that people shouldn't be going into hospital to die, they should go into hospital to be made better. Now, of course, that's true, but people are already going into hospital now who will never come out of hospital. And what I understand from these proposals is that actually this is about giving choice to people. People probably won't choose to end their own lives with assistance in hospital. They may well choose to do that in their own homes. That's very likely what's going to happen, or in the home that they happen to be living in towards the end of their lives. And again, it's about dignity. It's about doing that with safeguards and with medical assistance. And let's remind ourselves that this is also for a limited number of people who believe that towards the end of their lives, they have to have a serious condition, which is terminal, and where the suffering is unbearable and it is expected to cause them continued pain, and they are in an end-of-life situation, sir. And it also, here's the key bit, it has to be a clear and settled desire for them to do that. So it's not a case that there's going to be a doctor walking around a ward at the general hospital or in a care home with a syringe saying, who can I get rid of? Who am I going to get rid of today? That is completely unacceptable that that idea is being brought into this debate when it's so far from the truth, because it is all about professionalism and about a clear and settled will of the individual. So, sir, I had to put those comments on record. I do believe that ultimately this boils down to a fundamental question about who does one's life belong to? Does it belong to anyone else but yourself? I think the answer is no. I think we are all responsible for one's life. So whilst we can't be responsible for the circumstances of our birth, we can hopefully be responsible for the circumstances, some of them at least, the big decisions that we have in life. And certainly one of those decisions should be the manner in which you might choose to die, the manner in which you choose to leave this earth and to leave your loved ones. And again, it comes down to the ability to say, I may never ever want to use this. It might be something that I can bear, but recognizing that other people have different belief systems and that other people perhaps do want that safeguard at the end of their life, which is to have choice, sir.
Thank you, Deputy. Deputy Doublé.
Thank you, sir. And I listened with interest to the previous speech and also Deputy Miles' speech. I think we share broadly the similar views on this proposition, and I note that her speech was very brief, and I'm going to try to do the same. I do have a lengthy speech prepared, but I actually feel as though on reflection, I have already said in the previous two in principle debates all of the reasons why personally how I feel about the principle of an assisted dying law. So I wanted to make some comments initially related to the scrutiny panel. So for clarity, I wanted to confirm that when the bailiff asks about the panel calling it in, that we will be calling this in, and we will be able to bring this back for the 24th of February sitting. And we are able to do this. I wanted to note as well, we obviously have had discussions with the Minister about this, and he has confirmed that his officers will be ready to receive the report and to make the turnaround for fact-checking to compress that timescale. So I wonder if he could just confirm that, because that will be critical to us meeting that deadline. It's going to be very, very tight. I believe that we can do it if we can stick to all of the key timings on that report. So I would also recommend that members consider giving some time to the report in the days before the 24th of February. It will be, I think, weighty, hopefully not too lengthy, but certainly the issues raised, that we have spent a considerable amount of time and had many, I would say, mini debates in our meetings, which I know the deputies often have to go off to other meetings afterwards, and sometimes we are left kind of hanging on a really important ethical point around a potential amendment. We are getting to the point where we have resolved all of those points, but I would really appreciate members giving the time to that report to weigh those considerations up, so that when we do come to the final two votes, that deep thought has been given to the report and to the amendments. And actually, although I obviously can't go into detail around all of the 9 amendments, some of the points that have been raised, some of the concerns and the points against, we have some amendments that will address some of those points. So it's reassuring to me, actually, that I feel the panel are on the right track with some of the amendments that we are working on. And I wanted to thank my panel again. As you can see, we don't always agree on everything, and I think that's okay. I think that's a good thing. I think that's where good quality scrutiny happens, where members get into a room together and have differing points of view. And as Deputy Balash said in one of his speeches, that I am in favour of assisted dying legislation. I think he's demonstrated that he is very much against it. And Deputy Curtis is brings balance to our panel, and I really appreciate all the different points of view and the way that we have been able to kind of hash those out together, and in a very considered and intelligent and respectful way. So that will be the tone of the report when we do bring that to the Assembly. I'm just going to pick through my notes, actually, and just pick out a few points and try not to make it too long. I do urge members to remember that we have already voted on the principles, and I do feel that this should just be a reflection of previous votes. I don't feel there are many new points, actually, that have been raised. And I was looking back at my 2 speeches, 5,500 words across the 2 speeches that I made in the 2 previous debates, so I very much don't wish to repeat myself. That's amendments. Okay, I think that's all for my kind of scrutiny points of view. And again, just to reiterate to members that we will continue at pace. We will continue working diligently. And scrutiny hat off. I wanted to very briefly remind members why, as a humanist, why assisted dying and having an assisted dying service is really important to me. And it's for people who have already passed, people who have already died. It's out of respect for them, people who have already died awful deaths, and for the families who have watched them die in horrible pain, and people who have had to travel abroad for assisted deaths. And many of us will remember Alan Dushma, who was diagnosed with an aggressive terminal brain tumour. And I think he was known as an intelligent man and had a clear and settled wish to die on his own terms and with dignity. And whether we're bearing in mind prominent islanders who've had experiences and spoken out, or we're bearing in mind our own family experiences, I actually think of my own grandmother, who I think had what was, I think, a very good death, in that she was surrounded by her family. And she had a choice of where she was. She was in her own bed, and she had her family members there with her. As a humanist, I believe firmly that this is the one life we do have, and I actually believe that when we die, that's the end of it. That's the end of our life. And it's hugely important to me to live a good life, and to live a life that involves being considerate of my fellow human beings and making ethical choices based on reason and evidence. And for me, that means at the end of life, having choice and having autonomy over how one's life is to end is something that is hugely important. And the last thing that I wanted to finish on, actually, was I came across something on social media, actually, and it was an account of a woman who is an end-of-life doula. And I had never heard of this before I met, actually, a different person, a humanist woman who is an end-of-life doula, or sometimes called a death doula. And these people, I mean, the work that they do is so valuable, and it's about helping people to have a good death, to have a dignified death, sometimes with meaningful rituals involved, and sometimes planning that death with the doula. And I think sometimes we get caught up in, especially those of us who are speaking in favour of assisted dying, having an assisted dying service, we get caught up in the reasons why the alternatives are bad and why the suffering is bad. But actually, what I don't think we have talked about very much is what a good death can look like in a jurisdiction that has an assisted dying service. And this person who I found, who is an end-of-life doula, who provides the emotional support, practical guidance, and at the end of life, she wrote a description of what actually happens when somebody accesses an assisted dying service. And I wanted to read it out to members because I think it's important that we also think about the good that we can do, not just what we are trying to resolve. And she said, and I will paraphrase slightly, "I got a last-minute call to be present for a medical aid in dying ingestion this afternoon. The person sometimes are so sick and suffering so greatly that the process can be expedited as a final act of mercy. Sometimes when I work with people who choose this, we have weeks or months together to prep and plan and ritualize. And other times, like today, I'm showing up to a stranger's door, someone I've only spoken to briefly on the phone once, at the same time as the specialty pharmacist, ice lollies and apple juice in hand. These are supplies for the ingestion. It can be hard when I feel like I can't offer what I normally would, or when ritual or flowers or candles or music are declined by someone and their family. But I take on these clients because when I decided to be a death doula, I knew I wanted to show up for all death, the beautiful and profound, the quiet and unfair. It's all deserving of care and softness. So while almost all of the things I carry in my death doula bag went unused today, what I could still offer them was grace, compassion, deep understanding that ending suffering is both freeing and heartbreaking in the same breath. A choice of flavour of ice lolly, one last moment of agency. My client died peacefully and quickly after she took the medication, holding my hand while the TV quietly played in the background. I softly encouraged her husband to get in bed with her if he wanted, to snuggle her and memorize her face and body one more time. He took her other hand and laid his head on her arm, and I mirrored him so we were eye to eye. It doesn't feel real, he said, a tear falling from his eye. I know, I gently replied. And then we were just in it, the liminal space that is immediately after death. We laughed about how horrible the hold music is on the hospice phone line, and I listened to story after story after story about his love. And there ends the quote. And this really struck me, sir, because it painted such a picture of actually how beautiful and freeing and heartbreaking that moment can be. And that's what we will be giving the people of Jersey, is the choice to have a death like that. So I will be keeping in mind that story when I vote today, and I will be voting in favour.
Thank you, Deputy. Deputy Renouf.
Thank you, sir. So a couple of weeks ago, Deputy Miles and I attended a public meeting at Le Canave School to discuss the assisted dying law in the interests of public engagement, with a presentation from government officers. 2 members of the public turned up. And I'm told that similar recent public meetings elsewhere in the island have also been poorly attended. And this contrasts with a public meeting that we also held at the school before the previous debate on assisted dying, which was attended by 50+ members of the public. The conclusion I draw from this is that as far as the public is concerned, the decision has already been made. The main decision is no longer a debate for most of the public. Of course, there are people who, for very good reasons, remain opposed and probably always will be opposed. But as a whole, I do believe civil society has moved on. And I think they want to see us enact the decision. There have been many good speeches this afternoon and some interesting points made, which have made me think about the matter from new angles. The Constable of St. Helier spoke about the risks of pressure being put on people, but it was interesting to me that he refers to matters that are not covered by the legislation. No one is keeping an eye on the processes around wills, for example, as they would be around assisted dying, should we pass this legislation. And I think what some of those points miss is that the process around assisted dying would be far more thorough, more visible, and far more intense than is currently the case around the process of dying. Assisted dying will be intensely regulated and controlled. And I think back to right at the beginning, when I first became engaged in this process, when we heard from a visiting professional from Australia, a presentation which had a profound effect on my thinking on this matter, about the need to be certain of consent and how paramount that is. And that person from Australia, I think she was actually from Britain, but she lived in Australia, she spoke eloquently about how professionals err on the side of caution. In her telling of it, the hardest decisions she has had to take was saying no to an assisted death, because she could not be absolutely sure that all the conditions had been met. To Deputy Balash's point about the complexity and the bureaucracy, there is no doubt that the assisted dying service will require resource. But I do think that many of the posts he talked about in his long list are posts are people that are already employed. They will take on new roles, partly on the side of their current work. They will be seconded or they will take time to do this, but they are not all new hires, and I think we should take that into account. In terms of the number of people who might take advantage of assisted dying, it is, I think, indeed likely that only a small number will go through with an assisted death. It may only be a small number, but we treat people with rare conditions, medical conditions, at great expense on a fairly regular basis. And so I do not think that that is a fundamental, the small numbers of people involved, or is a fundamental reason not to support this. And I would also say, I think somebody has already mentioned it, that we may be overlooking the comfort that it will bring to people to know that the option exists. The experience in Australia suggests that it helps people to know that they can end their life should the pain become great, too great. I therefore come back to points made by Deputy Ferry at the point of this, at the early stages of this debate, who I think summarised the issues well, that assisted dying rests on the importance of people, giving people in desperate circumstances a personal choice. And as Deputy Ferry also said, made the point eloquently, that protection is also absolutely central and central to the legislation that we have before us. The Constable of St Helier is not alone in having had recent experience of someone close dying since we last voted. I'm not going to go into the details. I commend Deputy Scott for having the courage to do so, except to say that it was harrowing, despite the very best efforts of skilled and caring professionals to help. Nothing I experienced at that time persuaded me to change my support for the principle of assisted dying. As an island, I think we should be quietly proud of the way we have approached this issue. The building blocks have been patiently built up. The citizens' jury was a key element. There has been sustained engagement with civil society. Lobby groups have contributed, they have been heard. Civil servants have approached the matter with great care, and I would like to thank those officers for their patient and calm approach, particularly in public meetings, some of which I have attended. And as I said earlier, I commend the Minister and his team for his oversight of this process. It has, I think, been a good example of how to build a consensus for change. I might, in parenthesis, say that it's perhaps a process that we might look at in terms of other changes that we might try and, when we try and effect significant change in society, that kind of patient, careful engagement, certainly a lesson I might have learnt with some of my experiences as Minister. Not everyone is happy with the result, of course. Many people will feel they haven't been heard enough. But as a whole, my feeling is that the middle ground, if you like, feels like the island has reached a settled decision. And that is probably why there is no longer so much interest in attending a public meeting and why our inboxes are nowhere near as full of emails this time round. So I am content that the principles of the law follow the intent of the Assembly's earlier decision. It is clear to me, following briefings, that a huge amount of thought and care has gone into drafting this law. I am pleased that scrutiny have also spent so much time and care over their work, and I look forward, therefore, to debating their amendments and any other amendments when we hopefully reach the second and third readings. Thank you, sir.
Thank you, Deputy. The Dean.
Thank you very much indeed, sir. And I'd like to echo what the previous speaker has just said. I think lobby groups have been heard. And it's certainly been clear to me, as someone who's taken a personal interest in this for all sorts of different reasons, not least because my inbox was pretty full, that we have been heard, and I want to thank the Minister for that. I think it's been a good process in terms of listening to stakeholders who have expressed concerns. I've attended briefings where questions I've asked have been answered courteously, and it's clear that there are some robust safeguards in place. So I really do genuinely want to thank. I think the process has been good. There's three things I just would like members to reflect on as we move forward with this. And the first is with regard to coercion. I sat and watched a TV programme not too long ago about the actions of John Smythe, who is, some of you may know, is one of the most prolific abusers of children that took place in the church. It was a two-hour programme, 2 separate hours. I got to tell you, I sat watching that programme with tears screaming down my face. I could not believe what had happened, despite scrutiny of people around. And the question I asked myself was, why did this is a man who beat other people as allegedly as a sort of Christian discipline. Why did people go back a second time and allow it to happen? Why is it in domestic abuse, marriages where that happens, people go back? And it happens constantly. And that, of course, is part of the cult of personality, where it's really important that we pay attention to power. And I read very thoroughly the whole thing. It's here. I sat and I read it through a couple of times. There are very, very good safeguards in place, and I'd like to thank the Minister and his team for listening to those of us who expressed concerns and to see them sort of being headed off with legislation put in place. My request really as we move forward in this is that attention is paid to power, so that the kind of coercion that the Constable of St Helier has spoken about is not a possibility, so that training is so intense and so professional and so good that there isn't room for any of that kind of coercion, that people are on the lookout for it. You know, we all know that people can be kind and caring and compassionate. But my experience, tragically, as 36 years as a priest, is that I also know people can be cold and calculating and callous. And the place where I've seen that most at work has been within the families of the people affected. So that's my first point I'd like to make, really, without making any judgment on that. That's your task. I offer that reflection. My next reflection, if I may, is to talk about suicide. We have a new suicide prevention strategy in place. I don't know if you've read it yet. It's a very good document. It's a very colourful document. And I recognise that assisted dying has been declared not to be suicide. But no matter how we dress it up, we are giving permission for people to end their lives. My concern here isn't so much that. My concern is the message that we send. We have young people fearing for their future, who can't see a way forward because there's little opportunity. The world is in a mess. We have failed to deliver in so many ways. Mental well-being is extremely fragile due to various factors. And we've worked hard to prevent that with tight resources. And I note, as I read through the suicide prevention strategy, that there is no funding that I could see. I may be wrong, but I could see no additional funding to the suicide strategy moving forward. The report says some deliverables require additional resources, and their implementation is therefore contingent on the availability of these moving forward. I just feel there's a bit of a disconnect there. So my plea again, moving forward, is that if this legislation is passed, that attention is paid to suicide prevention. I know that's a slight tangent, but in many ways it isn't, because, you know, does suicide prevention cease to be a duty when someone is terminally ill, for example? That's a pretty important question to ask, particularly when we might be offering assisted dying. Where do people sit with that? Where's the funding for that strategy? So that's my second question. My third question as a priest is about pastoral care. And I'd like to thank those people who've made themselves incredibly vulnerable this afternoon by talking about some of the experiences that they have had. I wonder if anybody in this assembly has spoken to any family members who have taken up this assisted dying and who did die. I have done that. And one of the things that I discovered is that there's an awful lot of guilt surrounding that and a lot of mixed emotions. And I do think we need to get away from this sense of warm and fuzzy and you know, everyone walks with a neat ending in life. That's lovely, but there's often a lot of jagged edges left behind. The people that I spoke to were left with quite a lot of anxiety, quite a lot of regret, and a significant amount of guilt. Assisted dying will not wash those feelings away. And I think the provision that we offer to families needs to be extremely significant, and will probably place extra funding upon those resources that are already being allocated. You know, as someone who's constantly involved with families in pastoral care, I looked through some of the scenarios presented in this report, particularly scenario 2, where a husband had chosen to have assisted dying, and his wife objected and he didn't want her to know, and the daughter came and supported them. And I looked at this scenario. I know it was only a scenario, but as a priest, my eyes looked at it and I saw a pastoral battlefield with corpses laying everywhere. And I was thinking to myself, who will pick up the pieces of this as we move forward? So that's the third thing that I think I want to say to the Assembly. The provision for families and picking up the pieces needs to be very, very robust. And the last point that I wanted to make, and this may well come under the articles, I was a little bit concerned that an administrating practitioner, once they said yes to being part of the system, could not then say no. Maybe that's something that's been swept up by scrutiny. It looks like it is, so it looks like that point's been covered. But I think so. I'll end with that and thank members for listening.
Thank you. Deputy Howell.
Thank you, sir. This is the most difficult and complex proposition that I, as part of the Assembly, have had to debate. I have personally spent very many hours worrying about the possible change to the law. I'm very pleased that we have just voted to improve and enhance our end of life and palliative care, because I think that is so, so important. And I think with good palliative care, then we shouldn't be needing any assisted dying law. I, like Deputy Balash, do not think that the assisted dying should be part of our healthcare system. Our law is going to differ from the Isle of Man's. The Isle of Man, I think, is just you yourself take something. Our law is going to be possibly with somebody administering a lethal cocktail to you, so you die. And it will alter the doctor-patient relationship completely on this island. And there are many doctors who do not want to be anything to do with this. They are really, really concerned. They have come to me and said, please, please do everything you can so that this doesn't go through. In the summer, I think you, sir, when you were Deputy Bailiff, very kindly handed me the baton of hope. And then I came to this Assembly and talked against suicide and about suicide prevention. And I worry because it's a fact that where assisted dying has been introduced, there has been an increase in the suicide rate. We are saying, on one hand, we think we should have a suicide prevention strategy. On the other hand, we are saying, it's okay. At the end of your life, you can just take your life. I appreciate everybody thinks it's all about autonomy, but for me, I think sanctity of life is more important. As I said last time, I think some individuals may think they're terminally ill, but I have evidence of at least 3 friends who are still alive very, very many years later, and they could have taken their lives, but they have supported their families for all that time. The views of Tanni Gray-Thompson and Liz Carr, I really understand what they're saying, Liz Carr is terrified. She produced a video called, or a programme called Better Off Dead. And those, she summarises in that, the views that I share. I do not think we should be changing the law, sir. And I really urge people to vote against this proposition.
Thank you, Deputy. Deputy Luce.
Thank you, sir. I won't take long of members' time. Deputy Ferry at the start of this debate said this was a hard decision. And Deputy Howell has just said it's a difficult decision. But I want to say to members that for me here today, it's neither hard or difficult. Yes, it's incredibly important, but I don't find it hard and difficult because I voted in favour in the previous two debates, and I will do so again today. That's it, sir, because today is about the principles, not the detail, the principles. The principle of allowing those in unbearable pain and distress, after they've developed and had confirmed a terminal illness, allowing them the option to have control over the manner and timing of their death. How we do it, how they do it, what safeguards we put in place, all that detail comes in the second reading. But for me here today, sir, this, as well as being a hugely important decision, is not hard or difficult, and I will be supporting the Minister.
Thank you, Deputy. Does anyone else wish to speak on the... Deputy Miller.
Thank you, sir. Sir, I don't want to repeat things I've said in the previous debate, but I think my memory is that I planned my speech quite badly and I was timed out before I got to this final point. I think part of the problem we all feel, we all have in this subject, is that we are just not good at talking about death. As a culture, it's just not something we think about. We all pretend it's not going to happen to us. We all think it's not going to happen to us. We all think we're going to live longer and longer and longer, but we're not. And we need to start being more aware of death and just thinking about it and being open to it. And I might have a slight advantage in that because we've talked about death in my family since myself and my brothers were young children. And when I say young, I mean primary school. My dad always told me, from a very young age, my dad told me two things. Firstly, he didn't want to be kept alive in a machine. And secondly, that he wanted to be cremated. And he was adamant about those two things. And he told us all that regularly over the course of his life. And we only had one kind of real, we only had to kind of really go into it once where he was incensed, absolutely outraged that his brother had been cremated, as was his wish. But the family had then interred the urn with the ashes in a little plot. And my dad was absolutely convinced that this was not what his brother had wanted. He had not been cremated. And we had the debate, well, he clearly had been cremated, which was what he wanted. No, it wasn't what he wanted. Anyway, we won't go into it. It was a long going round in circular debate, which we had frequently. So I asked him what he wanted done with his ashes. And that pulled him up a bit, because he hadn't thought about that part of it. And initially said, oh, well, do this, put me there. And my brother and I both said, don't be ridiculous, we're not doing that. Think of something else. Anyway, a couple of days later, he said, I've decided what I want. I know where I want to go. So we said, fine, that's absolutely fine, we'll do that. And when the time did come, those conversations were very helpful, not just when my dad did end up in hospital at end of life unexpectedly, and I told the doctor about his desire not to be kept alive by a machine, and that was really helpful in our discussions about what we did. And then when we did eventually manage, despite COVID, to go and scatter his ashes, for me it was a very happy day because it was taken longer than I would have liked and that I think he would have liked. And for me it was quite a happy day because it was our final send-off and we were doing what he wanted. When I had that conversation with my mum after later, she had no hesitation in telling me what she wanted done with her ashes and confirming she also wanted to be cremated. So we have to talk about it. We have to think about it. We have to tell people what we know. A couple of Christmases ago, I was with my brother and a piece of music came on TV and I said in a completely offhand way, I want that played at my funeral. And my brother responded by saying, yes, and I want A, B, without pausing for breath. Yes, I want A, B, C. Sadly, the only one I can remember is Iron Maiden, Number of the Beast 666, in whichever order that comes. So we will have to check that. I expect the other brothers are going to have a very similar playlist. So it's going to be loud. But we do need to talk to people about our wishes, particularly about things like organ donation. It's very important. Families know about that. And our funeral wishes and what we want. So we just need to be better at talking about death and making sure that people know what we want. I think the concern that we will have a cohort of medical professionals who will abuse this system, I think is misplaced. And I think that is one of the good reasons for having it done as a public service and not within privately funded GPs. We have a different medical system. The doctors doing this will have no personal benefit to offering someone, to agreeing to help someone with an assisted death. They have no reason to push this. And I'm sure some people will be cross at this comment, but I am quite sure over the centuries, many doctors have and will continue to help their patients on their way, even now, even without this law, that there will be ways of doing that. And lastly, the question of suicide, which the last two speakers, I think, have mentioned. I was technically coroner for a while, and I have done a couple of inquests which may or may not have involved suicide. Suicide's a horrible thing. It really, really is. People take their lives in ways that are awful. They're awful for them, they're risky for them, they're intensely painful, they're horrible, and they are awful, awful for the family. And I would like to think that an assisted death in this way, where somebody's clearly made the decision and it's been done in a contained and calm, in a way that avoids pain, should involve much less guilt than suicide does when it happens in real life. I have an experience of suicide when I was 19, and it stayed with me for a very long time. It is a terrible thing to live through. It's a terrible thing for the family, and I would like to think that an assisted death in this way is way, way better for everybody than someone taking their own life in any kind of inventive way, because if someone makes that determination, it's a difficult thing. And one example I would give of that, if you people of an age will remember, returning back again to the music industry, when Michael Hutchence died, there was a finding of suicide. And his partner, and the great love of his life, Paula Yates, spent a long time campaigning to have that verdict of suicide overturned in favour of accidental death in the middle of a sex game or sexual act. And you would initially think, why on earth would you want to do that? But if the love of your life takes their own life and you don't know, it's horrific. It's absolutely horrific for people who are left. So I think suicide, we absolutely have to do everything we can to stop it, to prevent it, and find a way of making young people more optimistic, making everybody more optimistic, that there is always something in life to live for if you're in good health. But this is a different thing. Assisted dying is a different thing, and it needs to be considered in a different way. Thank you, sir.
Thank you, Deputy. Does anyone else wish to speak on the principles? Deputy Gorst.
Thank you, sir. I suppose my comments aren't going to come as a surprise to anyone, but I just wanted to spend a few moments talking about the value of life. We've heard a lot in this debate about freedom of choice, about autonomy to decide. And as I've said previously, that, of course, is a powerful argument and isn't easily argued away, because we make all sorts of decisions about our lives during the course of our lives. And the question is it really any different then if we are suffering and have a terminal condition at the end of our life to make those decisions? And one could argue that it isn't much different. I would argue that there's already the ability for islanders and citizens to make decisions about the end of their life without this piece of legislation, to decide not to be resuscitated, to decide not to continue with a medical treatment, and to be supported through that decision. And of course, I know that those who drafted the law and drafted the policy feel that that's a little bit hit and miss, and that it's unsafe. And you can argue in the world of health and safety and public liability, where nurses and doctors are rightly reviewed, that have we actually overstretched what we expect? We should expect our health professionals to do what they think is right for the patient, and that can mean administering pain control to a strong dose, and that is how things have happened with professional medical skill for a long time. But we live in a world where there seems to have to be a legal framework, a legal underpinning, a piece of legislation for everything. And I understand that argument, being a member of a legislature, but I also worry about it, because when you've put something down in black and white, it creates inflexibility, and it can create unintended consequences. And so for me, I am concerned, as we get to this vote today, that we can vote to give freedom of choice and autonomy in the way that the law is going to suggest over end-of-life decisions. But I worry that that freedom that those of us with agency, those of us who aren't vulnerable or elderly, we can make that choice reasonably freely. What I worry about is those without agency over their lives, those who are the most vulnerable in our community, and those who are elderly. Because what value are we putting on their ability to choose? Because I think coercion is a real problem. We heard Deputy Howell talking about those disability campaigners. And for my part, despite all of the good work of the safeguards in this legislation, it isn't sufficient, and I don't think it gives us sufficient confidence that there won't be some potential for coercion and potential for those vulnerable members of our community to feel that their lives are less valuable. And that worries me greatly, because who judges the value of one's life? It's incredibly important that we in a legislature and we in our community, which prides itself on the value that it places on family, on community, on the island, working and supporting each other, that prides itself on that approach to life, that we aren't judgmental that one life is of more value and more worthy than another for whatever reason. And so, of course, I know I've counted the numbers on the previous votes. I've counted the numbers on deferral to a scrutiny. So we have a good indication of where this first reading is going to go today. But I do just ask members to be mindful as we get through this first reading, and then we'll come to the articles in due course, to be mindful of that principle, that we shouldn't be judging the value of another individual's life, suggesting that just because it's not like ours, it may not have as much value. And I am very concerned that as we introduce these changes, that will fundamentally change some of the, I think, the greatest attributes that this island has of support for family, support for community, and support for all of us in this island. Thank you, sir.
Thank you, Deputy. Ronald Iverson, John.
Thank you, sir. So I hadn't intended to speak on the subject, having previously spoken about some of my own recent personal experiences on the previous 2 occasions we've debated this. But like Deputy Miles and others, I'd like to place on record my support of the principles. So the Dean has spoken about pastoral care. Make no mistake, assisted dying is not an easy option. But, sir, neither is it easy for those families who witness their loved ones suffering intolerably at the end of their life. People have spoken about Switzerland, suggesting, I believe, that people could go there. Well, sir, perhaps you can, if you can afford it. But sadly, not everybody can. People have also spoken about the level of resource needed to implement this, calling it bureaucracy. Sir, I also pay tribute to those people who have done the work behind the scenes, and I wouldn't call it bureaucracy, sir. I would call it safeguards. People have also spoken about coercion. So let's not kid ourselves. Far too often, where there is a will, there is a war. And Deputy Tadier spoke about opportunists abusing people's funds whilst they are still in care. So those things won't go away. And given the level of safeguards or bureaucracy, I'm less concerned about coercion than I was when we first debated this in 2021. So the reason I wasn't going to speak was that I currently have a very close relative who's receiving palliative care. They've been battling an illness for 6 years and are going through an extremely difficult time at present as they head to the end of their life. So also on Sunday, I was walking Sunday morning with someone who's in the early stages of Parkinson's, and I'm pleased to say that they're managing their condition extremely well. However, so whilst walking, we discussed someone that's both known to us, and unfortunately that person has severe symptoms, and the person I was with asked for assurance that they wouldn't be allowed to get into that situation. So I was pleased to give that person, a close person to me, sir, that assurance. So whilst I fully respect others' views on this subject, I will finish by repeating 2 comments I've made previously. Supporting assisted dying will not result in more deaths, but it will result in less people suffering an unbearable end to life. And finally, sir, the late Gary Burgess thanked me following a previous debate for mentioning a quote that he had made, and I'd like to repeat that today, sir. It's my life, and I shall be free to do what I want as long as it doesn't affect other people. Sir, I will be supporting the principles, and I ask others to do the same. Thank you, sir.
Thank you, Conrad St. Martin.
Thank you, sir. The Dean, in his very eloquent speech, mentioned the anxiety and guilt suffered by those whose loved ones have used assisted dying. Conversely, there are families who suffer anxiety and guilt when one's loved one suffers a long, excruciating, painful death, which no amount of medical intervention or all the love in the world can alleviate their suffering and cannot take away their pain and distress. I won't say any more, but I would just say that I would be voting for the principles. Thank you.
Thank you, Conrad. Does anyone else wish to speak on the principles? Deputy Rob Ward.
Thank you, sir. And I think we demonstrate the importance of our decision today. I come from what is initially an incredibly simple and perhaps selfish position, which is I would like to decide if I was, I hope I never am, terminally ill when and how I die. It's a selfish, individual position. I recognise that. I don't want to force that decision on anyone else, but I do believe they should have the right to make the same decision I would want to make. I'm not a religious man. There are surveys that say, I think the last survey said that 49% of people, I don't know, surveys are surveys, and we don't know. I have no issue with all of the myriad and welcome those different religious views on our island that enrich culturally our island, those who have no religion who enrich culturally our island. But and I have no issue with anyone's firm beliefs that they would not engage themselves in any form of assisted dying because they don't believe it to be morally or spiritually right. That's absolutely the right of an individual. I see nothing in this law that will force that to happen. I believe there are safeguards, and when it goes back to look at the regulations and amendments come through, those safeguards, if necessary, personally, I don't think they do need to be any safer. I think there are enough safeguards there to satisfy my wish. If it was me, I would say there's enough safeguard there for me, and that's, again, the individual, personal, selfish approach, which, you know, I'm being honest about, I think we need to think about. But I think there are enough safeguards. But nobody is forced to engage in this if they don't want to. And I think that's a really important point. If you object to this morally, that's absolutely fine. You have the right to do that. You have the right to decide for yourself as to what you do. I do not see this law stopping that for anybody on this island. But what I do see is the opportunity to alleviate suffering. And if one is diagnosed with anything, and we all go through experiences for a couple, the first thing that happens, and this isn't a criticism of the health profession, but I do feel that the first thing that happens is you lose control. You lose control of what's happening to you. You lose control of the decisions perhaps that you're making because it's complicated and you're right in the centre of it, and the experiences you're having to consider, and you're considering so many different issues. And good care gives you back that control, gives you that understanding, and gives you that opportunity to take control of the situation that you're in. And to me, this is the ultimate enabling of control over what you want to do. And so what it allows is you to do what you want to do. And you may want to say, no, I couldn't see myself doing that. I just want good palliative care. And the law we passed just now, the legislation we passed previous to this, makes a recognition of the need of that palliative care, and I would absolutely support that. But so I think that final decision as to where you go, and there are, I mean, so I have to be honest, I voted for unbearable suffering as well, pathway 2, and that wasn't agreed, so I was fully prepared to say to people, you have absolutely full choice in what you do. However, I can accept where we are at the moment with path 1, as was accepted before, and that's what this law does. And I would urge members to vote for those principles today, because then we come back to the articles as amended. I know there are scrutiny panel amendments coming, and the scrutiny panel will take those in, and then we'll see those, and then we can have a wider debate on the specifics of whether or not those things are working and whether we want to add. I know there's an amendment from the other Deputy Ward in this Assembly. I personally don't agree with that amendment, but we'll come to that debate at a time, because that's what we do here. And I have to say that's what we've done well around this legislation. We have debated it well. There have been honest, open, you know, emotional, and there's nothing wrong with it. We need some emotion in our politics soon, sometimes, because it shows that we're human beings who are making the decisions in this Assembly. And so therefore, sir, I would say, from a personal and a wider point of view, I cannot say to anybody, you will not have that choice in good faith. In the end, sir, whatever may happen, I may decide I don't want to have that choice. But that will be my decision. It will be my ultimate right, to be my human right, be my right for me as a human being on this planet to decide on my outcome at the end. I may one day, sir, discover religion. So, with the guidance of, I look around, we have, there's a hope for everyone. And so I will say that we have differences, but I absolutely appreciate the conversations I have with religious leaders on this island, because I know many of them. There are many different religious groups in my constituency, and I always learn something. So, but at this time, I am quite, I can't think of the word, I'm quite satisfied with the ability to vote for the principles of this piece of legislation, because I think it gives the freedom, opportunity and right to every individual to make the choices at the end of their life. So the details on why that is the case have been talked about by so many different people. The details of the safeguards, etc., have all been through. But I'll finish by saying just briefly, I don't just want it for me, I want it for the loved ones around me, because I want them to understand that it is my choice, that I have considered that carefully. And I would need, and I don't know what it would be like at that time, so I hope it never happens, to respect and understand their choices as well. This is a mutual respect thing for everybody that we live with. So, sir, I just urge people to please support the principles today. We can go back to the articles and the amendments that come with them, and then we can debate again in detail. And hopefully, sir, we'll come up with a law that is satisfactory to everybody and alleviate suffering in our society. Thank you, sir.
Thank you, Deputy. Deputy Mezek.
Thank you, sir. I wasn't able to participate in the last debate on assisted dying, so I'm pleased to be able to do so in this one and just put on record my reasons for supporting it. So like Deputy Ward, I'm also not a religious man. I don't believe that life is any kind of gift from above or a miracle. I don't believe miracles exist, although I'm sure some will claim to see some on the 7th of June this year, sir. Thank you. It took a moment for the penny to drop there. Life is simply electrical signals in a brain that have somehow manifested themselves into what we define as capacity and consciousness, and in human beings that happens to such a sophisticated level, although of course that varies from person to person. So that's another one waiting for the penny to drop, maybe a little bit longer there. So, but the fact that after billions of years of the existence of the universe and every little thing that's happened along the way, that we get to our own personal existence is against the odds, is as close to something that could possibly be defined as a miracle that I can full well understand why it's treated with the sanctity it is, and I agree with that. And perhaps we're only millimetres apart in our positions here between myself and Deputy Gorst, and that ultimately, sir, is why the debate is so important. But also, sir, it leads me to that conclusion that for each of us who has our own life and our own world that we see through our own eyes, our own capacity and our own consciousness is unique to each of us, but it is what is deeply personal to each of us on an individual level and is ours and ours alone. It doesn't belong to anyone else. And so I have to say, I find ultimately the reason I'm in support of assisted dying, putting aside all of those really important considerations about capacity and caring for others and wanting to alleviate suffering, is that I just fundamentally consider it to be authoritarian to tell other people that they cannot do what they want to do with the thing that is theirs and theirs alone and most precious to them. And whilst everyone will have different personal reasons for making whatever choice they make at the end of their life, I think that some of the examples that some members have used of those who were glad that assisted dying was not an option when one of their family members went through them passing away, is that they missed the point fundamentally about what this is about, which is consent. If you find, as you reach your final days, that in you is the desire and the will to live a bit longer so that you can witness something you want to witness, whether it's a milestone for somebody you care about or another event or anything like that. That is ultimately your right and your choice, which nobody should ever seek to take away from you. But it works the other way round, so where if somebody has, you know, with full capacity and access to all of the different options, have decided that for them, they would prefer that the moment came at a point of their choosing, in an environment of their choosing, surrounded by the people who they care about and with the moments that they want to have to say their final goodbyes or get across what they want to, then it should not be denied that opportunity to them, and it is authoritarian to deny them that when we, for where we have got to as a society, are capable of delivering it in a safe framework. This debate today is only on the principles, and I will vote in favour of those principles, and of course keep an open mind as to whatever amendments may come to the finer details on that, and I'll use my personal judgment on each of those to work out what I think provides the best framework and the most effective safeguards. But the debate today, though we've kind of already had it in different guises in previous propositions, is about that fundamental question of, do you believe that an individual should have the choice when they're facing their final days to have control over that moment where they finally do slip away? Or do you want to deny them that? A perspective which I regard as being a bit authoritarian. And so I'm pleased, though I missed the last debate on this, that for this crucial vote, I will be here to vote for.
Thank you, Deputy. Does anyone else wish to speak on the principles? Deputy Kovacs.
Thank you, sir. I want to speak not just as a politician today, but as a human being. As someone who has sat beside a hospital bed, holding the hand of someone they love. As someone who has seen suffering, yes, but who has also seen the quiet courage, the unexpected moments of tenderness, the dignity that still exists in the hardest hours. This debate has brought out the greatest fears and the deepest grief in our community. I have heard parents tremble as they describe the pain of their children. I have heard from husbands and wives who felt utterly powerless watching illness take what it takes. I have heard from people who are tired, scared, and searching for something that feels like control. I honor every one of them, and I feel their pain to my core. To the close family and friends I lost along the way, but also to the one that had lifetime remorse when she had to switch off the life support machine on her partner, always wondering, what if? But, sir, our duty is not simply to respond to pain. It is to protect people when their pain makes them vulnerable. It is to guard them when fear speaks louder than hope. It is to make decisions with a clear head while our hearts are breaking. It is to value life as well. The minister said that he's confident the law is robust, but confidence is not a safeguard. Confidence is not a process. Confidence is not a shield around frightened, depressed, or isolated islander. He confirmed people can self-refer. No doctor who knows them, no one who understands their mental state, no one who can recognize coercion, and coercion can be as quiet as sigh at the dinner table. He confirmed euthanasia will be part of this service. Think about what we are asking from our already exhausted healthcare workers. People who already cry in their cars after shifts. People who patch up trauma day after day. We are asking them to cross a moral boundary that cannot be uncrossed, in a system that is already collapsing under its own weight. And perhaps most worrying of all, the safeguards, the advocacy, the detailed protection, they're not written yet. We are being asked to approve the destination before we have even seen the map. That is not how you legislate for irreversible decisions. That is not how you protect life. The scrutiny panel chair said the law still lacks clarity in key places. If the very panel tasked with tearing this apart still has concern, how can we possibly say to the public, don't worry, it's safe? Being just an interim report, it also shows that scrutiny still needs additional time for review to make sure all the right safeguards are in place. In fact, their interim report lays it bare. While the draft assisted dying law generally meets the Assembly's intention, it still carries serious risks. There is the risk of coercion, especially for those who are vulnerable or who quietly feel like a burden. There is the complexity of assessing capacity, even if we remove the future consent waiver. There is the question of people with disabilities who may need extra safeguards just to ensure they are making a free choice. The law's flexible definition of terminal illness could unintentionally widen eligibility beyond what we agreed. And the two options, self-administered or practitioner-administered assisted dying, create practical and ethical challenges we have yet to fully solve. Add to that the need for clear palliative care advice, managing staff roles and refusals, possibly third-party appeals that could clash with human rights, and integration with end-of-life services that remains uncertain. The panel is clear. Even carefully drafted, these proposals still leave gaps. Gaps where a mistake, a misjudgment, a quiet coercion could cause irreversible harm. I welcome the end-of-life care proposal from the Minister. However, I'm disappointed to hear in his speech of that proposal we just approved that it was formulated in a way that if the assisted dying proposition it is to fall, this will fall as well. And this must remain in place regardless of what outcome of other proposals, exactly in the way the Deputy Jean highlighted at that debate. And then there is the communication plan. Leaflets, websites, promotion. Imagine being 84 years old, living alone after the loss of your partner, struggling to get out of a chair, apologizing every time someone helps you. Imagine a leaflet arriving that says the state has a new service. Imagine what that whisper becomes inside a lonely mind. Maybe my family would be relieved. Maybe this is the right thing to do. Maybe I'm in the way. We must not create a world where death feels like a duty. All of this, every risk, every emotional trigger, every failure, is happening inside a healthcare system that is barely functioning. We do not have reliable palliative care in the true sense. We do not have consistent mental health support. We do not have enough staff, enough beds, enough resilience. We are failing to provide sometimes the basics that preserve life, and we are being asked to create a service that ends it. Look into your own hearts. Look at the health system around us. Is this the moment, without deferring to have that assurance on all safeguard details for a law that requires absolute perfection, zero mistakes, and complete trust? Every one of us here cares about compassion. Everyone wants people to be safe and to not suffer. Every one of us wants dignity at the end of life. But compassion without caution becomes relentless. And the law built on good intentions, but not yet on solid foundations, becomes a danger. This is not about rejecting compassion. It is about refusing to legislate in a way that could lead even one vulnerable person toward the choice they do not truly want. When you vote, you'll carry that responsibility, not in the abstract, not in theory, but in real lives, real families, real consequences that cannot be undone. And so, before you cast your vote, I want to leave you with this. We are the last line of defense for those who cannot speak loudly for themselves. People who are overwhelmed, people who are scared, people who need hope more than they need a form to sign. If you are wrong and reject this today, you can revisit it later. We can strengthen safeguards, we can fix our healthcare system. You can try again later with more safety, more clarity, more humanity. But if we are wrong and pass it now, we cannot bring anyone back. Choose the path that leaves no irreversible harm. Choose the path that honors the vulnerable. Choose the path that values every last breath of an islander's life. And I do not support this proposition. Thank you.
Thank you, Deputy. Does anyone else wish to speak on the principle? Deputy Morel.
Thank you, sir. I'm pleased to follow the speech by Deputy Kovac. She touched upon similar areas to those which I've struggled with ever since this first came to us in the Assembly 2 terms ago. I think I apologise for repeating my speech from kind of 2024, but I do stand here, and as someone who is definitely a liberal when it comes to his politics and his way of thinking about life, I do and in my ideal world, I would have the ability to choose the time and manner of my passing, particularly if I was in pain or likely to be in pain. And so from that perspective, I've always approached assisted dying as something that, in my ideal world, I, as an individual, wish that I should be able to avail myself of. But I haven't, certainly I believe in the last vote, I don't believe I voted for this, and I won't be again today, because my problem is when my ideal world comes face to face and direct contact with the reality of Jersey as it is today, and everything that I have known and seen about our processes within government, within the health service and elsewhere. Many of you will know, many of you won't know, but I've spent the last 6 years with my mother suffering from Alzheimer's, and I've watched and been with her, as have all the members of my family over those last 6 years. Of course, such a process takes you in direct contact with the health service. And so it is things such as the 5-hour wait for a basic painkiller in the hospital that really stick in my mind. It is the records that never reached the care home. It's the constant chasing for assurances, or the constant chasing for actual prescriptions, or the constant chasing for those records, or actually what is happening to my mother, because no one's telling me right now. Please help us understand. And all of that over the last 6 or 7 years has really led me to keep coming back to this piece of legislation and say that I am sorry, in our ideal worlds, and I do feel that for many of us, that is how we vote for this legislation. We vote for it in our ideal world. But Jersey isn't an ideal world. It is a very real one. And I cannot get past all the problems that I keep seeing and facing with regard to procedures and processes throughout our public service, and particularly in regard to this within our health service. There is a lack of communication. There is a distance between the staff and the patients. There are real problems. I mean, I remember one meeting where they talked about my mum's end of life. One meeting, 15 minutes in the side room. Her team was there, first time we'd met her team. They told us she might live for 6 months, she might live for 6 weeks, she might live for 6 days, who knows. But don't worry, she'll be okay. That was it. That, to me, is not a system that is ready for this law. And that is the reality that I keep coming across time and time again in my head. I wish it were different, and none of this should be taken as a criticism of any of the leadership or anything like this. It's difficult. It is difficult in Jersey to run these things. But that's why I cannot support this in principle, because I do not feel that we are ready for it. I have listened, to so many views that are for and views that are against this. And, I am very pleased that earlier today we passed the we passed the proposition. It wasn't legislation. We passed the proposition about end-of-life care. I worry because it's quite right. Everybody wants, if this is to pass, and of course I understand that in principle it likely is to, but if this is to pass, I understand that it has to be perfect. It was my amendment to the original debates, I think back in 2021 or whenever they were, that asked for the extra scrutiny, the extra debate, the extra process, because I understood if we are to go down this road, we need to make sure it's as tight as it can be, it's as clear as it can be. But when it comes to it, the law kicks off a whole train of real life events. And I cannot see how this law is going to meet those real life events in the real life environment of Jersey's health service today. I worry, sorry, the point I was going to make, I worry that in order to make sure this is as tight and as working as perfectly as possible, we're going to invest so much in this particular piece of legislation that the proposition we just passed about end-of-life care will not receive the funding it requires ultimately. And actually, from everything we told, 99.9% of all people in Jersey will be going through the end-of-life care and not through assisted dying. Yet I feel that we're going to be focused on making sure this is Rolls-Royce, that the other one fades away and becomes just another part of business as usual. And unfortunately, business as usual at the moment is not good enough. And I've seen that with my own eyes. I am lucky. When my mum died 7 months ago, she died peacefully, she died painlessly, and to be honest, she died happily. But that's just her experience, and we're lucky that that's what came for my mum. For so many other people, that's not what happens. And they wouldn't have been eligible for assisted dying. My mum had Alzheimer's. She was never eligible for assisted dying. Ever, ever, ever. So end-of-life care is far, far more important than this is. Because that's 99.9% of all people in Jersey. And I know it's so hard. I do not like the idea of me dying in immense pain. I do not like the idea of watching my loved ones and my friends die in immense pain. None of us do. But that doesn't deflect me from looking at the reality of our environment today versus what I believe is an unattainable ideal on this law here. I think coercion is something I definitely talked about in previous debates, and it's something that obviously has been talked about today. And again, I think we underestimate the kind of range of possibilities that coercion can stem from. We think of it as families. And yes, I mean, one of the saddest things that's happened to me in my adult life, thankfully not to my family, is seeing how families turn against each other. And particularly when an inheritance is available, so to speak. I've seen what I thought were lovely families turn against each other in the most hideous of ways. Friends being, torn apart by their closest relatives. It's absolutely appalling. But that's just one place where coercion comes from. Nowadays, coercion can come from the other side of the planet. Coercion can come from that relationship you never knew your relative had with that person online, the other side of the planet. That's where coercion can come from today. It doesn't have to be a family member. It doesn't have to be a person that we know about. So when I read about the safeguards, obviously, if we know that Kirsten is in an abusive relationship and the person that is, that's known to social services and so on, so when Kirsten goes through this service asking for end of life, obviously there's something clear that the doctors or the officials, can pick up on and say, we're not sure, Kirsten's in a relationship, it's not a good one, he's likely that he's open to coercion, etc. That's easy to pick up on. People have relationships online that their closest relatives know nothing about. Yet those people online, the other side of the world, may well know exactly how much that money that person owns, how much wealth that person has, may well know all about the health status of that person. And so I see nothing about that in here. I ask, when does coercion become attempted murder? I ask about the penalties in here. If someone is coercing and someone has gone into the process and during the process it is found, oh my goodness, they are being coerced by another person to go into this assisted dying process, that to me is an attempted murder. You are trying to end the life of that person for your own gain. But I see nothing about that in here. If it's successful, if they successfully coerce and they successfully go through the system, is that murder? Again, I've never seen that question raised, but I think it is a question that is a valid question and needs to be asked. And so I still stand here today, and it is, as many people have said, the hardest piece of legislation, and this is at least the third time I've debated it. But I still stand here unable to get beyond the fact that as much as I want this, as much as I want this option for myself, for my loved ones, for your loved ones, in that ideal world, I know that that ideal world does not exist. And I cannot see how, with the systems that Jersey has in place today, the systems that I've experienced through, my mum's journey, don't like that word, that Jersey's not ready for this. And to make Jersey ready for this, I believe we're going to have to take resources from other places which will affect far more people than this will ever benefit. And so I'm really sorry. And I know, and I have to say, the very first time I met Deputy Tom Binney, he was a Mr. Tom Binney at the time. And he asked to meet me, and I was really grateful. And we sat in a room downstairs before he was elected, before I think he'd probably even thought about being elected. And this was something that Deputy Binney wanted so strongly, or Mr. Binney at the time wanted so strongly. And, you know, I'm so proud that he's, from then to now, got this here. And I'm proud that he's been able to move something that he passionately believes in, and I don't want to stop him. But I can't vote for it because I just fundamentally do not believe that our island can cope with it. And I don't think all the things that I've just talked about, coercion and the ramifications of coercion, have been really thought about. Is that attempted murder? Maybe, a lawyer can tell me. Is that, another part is, where are the penalties for officials in this process who abuse their role? There should be penalties for officials in their process who abuse their role, if they are ever found to abuse their role in this process. So I'm sorry. I know, and I believe it will be passed. I think this will be the third time that it's passed, and that's fine. But I cannot put my support behind this because I just don't think Jersey's ready for it. Thank you, sir.
Thank you, Deputy.
Chairman, sir.
Adjournment proposed. Members content to adjourn? Assembly stands adjourned until 9:30 tomorrow morning.